Good morning, everyone. We have 6 cases on today's argument calendar. We're going to proceed in a slightly different order from that published on the court schedule. We'll begin with case number 2 and then revert back to case number 1. So we'll start with the appeal in 24-17-19, Anthony Sellers versus the International Union Elevators Constructors. And we have, yes, is it Ms. Bichner?
Ms. Beechner, thank you, Your Honor.
Beechner, you're welcome. Good morning to you. Can you hear me okay from the courtroom?
I can, thank you, Your Honor.
Okay, and are the screens visible to you?
Yes, Your Honor.
Okay, go ahead and proceed.
May it please the court, Your Honor, my name is Darren Van Pembroke, and I'm here on behalf of the plaintiff appellant, Anthony Seller, who's present with me in court today. I'd reserve any time that remains after my opening remarks if necessary. Mr. Sellers is and continues to be a member of Defendant Union IUEC Local Number 2 and was an employee of ThyssenKrupp, a German elevator company with operations in Chicago, who filed a complaint against his union alleging that they breached their duty of fair representation by acting arbitrarily, discriminatorily, and in bad faith. The district court erred, in our view, with all due respect, in granting summary judgment to the defendants by ignoring what we believe are genuine issues of material fact, both with regard to arbitrary conduct by the union and discriminatory conduct by the union. Among the genuine issues of material fact have to do with the union's acknowledgement and receipt of information that Mr. Sellers was in fact subject to racial discrimination by TKE, and the actions of the union in determining that there was absolutely no evidence of that discrimination, and then admitting that they had done no investigation whatsoever. So the issue is not that the union has an obligation to investigate racial discrimination. The issue is when they take in information, and I'll get to this in a minute, and address to the employee that they will pursue it and do nothing, and then have no basis whatsoever to make a declaration that the charges against the company are not valid. And it sounds mixed up and strange, I admit it, because that is the arbitrary nature of the conduct of the union as it relates to Mr. Sellers in this case.
Counsel, you're focusing on the arbitrary and discriminatory parts of that test. Am I reading your argument correctly?
Yes.
Because the brief was not that specific in terms of which prong you were arguing under. So from what I understand, the written grievance did not mention race,
Right.
but orally, Mr. Sellers discussed race discrimination. Is it your position that if the union has some knowledge, despite what might be written in the grievance, the union has a duty to investigate?
I think there's first a factual issue that needs to be addressed, and that is that Mr. Sellers, the evidence shows, did not draft the grievance, did not see the grievance. The grievance was drafted by the union. In fact, there's record citation to the fact that Mr. Sellers had little knowledge about the grievance process. And in fact, I'll reference this because I think it's very important.
So who drafted the grievance?
The union.
The union. And there's evidence in the record?
Yes.
Okay. See, this is the problem, is that there has to be things brought together. You can't leave it to us to connect the dots.
And I apologize, that was not our intent.
Yeah.
But one thing I want to bring to the court's attention is there is this notion that Mr. Sellers never asked the union to investigate the discrimination he was subject to. And there's been case law cited by the defendant that says even if the union knows about discriminatory conduct, it has no affirmative obligation. And there's a citation to a record by the defendants that I think is incomplete. And if you'll indulge me, I just want to read a couple of lines, and I think it'll bring to light what we're referring to, if that's permitted, Your Honors. All right. Question is asked of Mr. Sellers. Anything else?
Can you just be clear? What are you reading from?
I'm reading from docket 68, page 74, lines 6 through 18.
Okay, and what is it?
It is the testimony of Mr. Sellers in this case, the plaintiff in this case.
Deposition testimony?
testimony.
Okay,
Yes.
okay.
Anything else the union did to stonewall you? Well, not taking my discrimination seriously or even fighting for the discrimination I was subject to by ThyssenKrupp. And what did you want the union to do to fight for you? Well, at least perhaps make a grievance regarding the discrimination. Did you ask them to do that? No, I didn't, just as well as I didn't ask them to draw up the grievance. They brought it to my attention. And what the defendants did is cite only that first line that said no. And what Mr. Sullers testified to is he relied on his union, and his union brought to him that they could file a grievance based on the discrimination he was subject to. But the reality is, despite telling him that, the union never filed a grievance on Mr. Sullers' behalf based on discrimination. There was a grievance that had been filed with regard to a layoff, and that brings me to another genuine issue of material fact. There is a factual dispute between the parties about whether the employer, ThyssenKrupp, is the one that said, we're not going to resolve your grievance about your layoff unless you drop your Illinois Department of Human Rights investigation. And the union's position is we were just carrying that message. But the reality is that the record that has been provided here shows that it was the union telling Mr. Sullers, in addition to TKE, you're never going to work at that company again, you're never going to work in this industry again, unless you drop your Illinois Department of Human Rights.
Where are the record citations for that
All right.
proposition?
Hang on just for a sec. Okay, docket 73, page 65, paragraph 2.
And what is that?
That is Mr. Sullers' affidavit. It says, John Vallone stated that Mr. Sullers must drop his claims of racial discrimination to TKE or by TKE, or he would not be allowed to return to work or collect the back pay he was owed. There's a further reference in that same docket, number 73, at page 65, paragraph 6. John Vallone's screaming rant at the plaintiff stating that nothing would be done for the plaintiff unless he agreed to drop his IHRA discrimination charges against TKE. There's another union official, his name is Eddie Christian, and that same document recites Eddie Christian's repeat of the same position by the union, that they're not going to do anything for Mr. Sullers unless he drops his claim.
And Mr. Van Pembroke, can you step back a little bit? Because I got to tell you, I came into this very much of a mind along some of the lines of the questions that Judge Maldonado is asking you, that I did not see anything suggesting that Mr. Sullers, in writing or orally, asked a union representative, Mr. Vallone or anyone else, to pursue a claim of race-based discrimination. I very much understood that he was upset about the other mechanic being hired during the stay-at-home or layoff period, or whatever the best way to characterize that is. I was also aware, or I gleaned as best I could from this, that he informed Mr. Vallone that he himself may go to the Illinois Department of Human Rights with a race allegation. But isn't there some obligation on his part to bring this to the attention of the union in terms of what he wants to grieve? Because how is the union otherwise going to know?
Right. So there is, I'll reference docket 71-1 at paragraph 9, where Mr. Sullers indicated, I repeatedly explained the many ways in which TKE had acted out of racial discrimination, including by laying off myself and Kenny Smith in April of 2008.
And what do you, can you just tell us what the documents are? The numbers
Yeah.
don't mean as much to me as they do to you.
It's Mr. Sullers' affidavit.
Okay, submitted when? At summary judgment?
Yes.
Okay.
And I'll go back to, I won't read again what I read earlier. He had a discussion with the union, and they said to him, we will bring to your attention what we can do for your people. The confusing part is the union takes charge of filing grievances. The facts are given to the union from the employee, and the union drafts the grievance and then pursues it on their behalf. Mr. Sullers says, no, I didn't specifically say, will you file a grievance on my behalf? They told me they could do it. So there's a discussion. And that's what we believe this testimony at docket 68, page 17, 16 through 18, his deposition transcript is fairly read as. And we think in the context of a motion for summary judgment, any ambiguity has got to be construed reasonably in his favor. He did not say, no, I never said don't pursue a grievance. And he said and really what he said is our course of dealings is when I have an issue that I think it needs to be pursued by the union or is a violation of the collective bargaining agreement, I go to my union representative, explain what's happened, and they tell me what to do. And what that testimony says is, Mr. Gonzalez told me we can file a grievance based on discrimination, but they never did it. And then they declared there was no discrimination without doing any investigation. That is arbitrary. That is a breach of the duty of fair representation. I want to talk just a little bit about the court's credibility determinations. I think there's no dispute that at a summary judgment level, a court should not engage in credibility determinations. And here, it's very clear that the district court unfortunately did just that. For example, we just talked a little bit about the grievance. The court tried to resolve Mr. Gonzalez's contradictory testimony of saying we didn't do any investigation, but there was no discrimination by saying, well, the grievance form is something that didn't include that information. The court didn't have any basis to know who actually filled the grievance form out. And they simply assumed it was the case. And we think that's a credibility determination that is not appropriate.
What does the record show, if anything, regarding Mr. Soller's knowledge of the content of the grievance?
I'm not going to be able to cite it to you right now, but I've read in Mr. Gonzalez's deposition that eventually Mr. Sullers asked him to see the grievance, and that Mr. Gonzalez said he had to check with his superiors because nobody had ever asked to see a grievance before. So I think the record's going to be clear that it was not available to. You would think in the normal course I'd fill out your grievance that I'm going to submit on your behalf and I give it to you, but this record doesn't have any of that information. That did not happen. All right, Your Honors.
You want to save your
Yeah, I'll save my 2.46.
No problem. Okay. Thanks, Mr. Van Pembroek.
Thank you. Can I say a word about Judge Flom? He's going to be missed.
Maybe, no question about that. Thank you. Okay. Ms. Bishner, over to you. Go right ahead.
Good morning, Your Honors. May it please the court. My name is Kathleen Beechner, here on behalf today of the International Union of Elevator Constructors, Local 2. I'd first like to thank the court for graciously agreeing to allow me to appear here virtually today, in addition to counsel for the appellant for agreeing not to oppose that request. Before I get started on a very brief summary of the case and the union's positions, understanding that the court has already read the briefs in this case, I just wanted to defer to Your Honors and see if there are any preliminary questions I could answer for you before we get started.
No, go right ahead.
Okay, so to respond to some arguments raised by the appellant here today, the appellant opened his argument by indicating that the union did nothing to pursue a grievance on behalf of the appellant, which is simply factually inaccurate. The union pursued a grievance based on the layoff as the day that Mr. Sullers came in and reported that layoff and indicated he'd like to file a grievance regarding the same. The union obtained the full remedy available for that grievance pursuant to the contract, which would be back pay and reinstatement to his employment with TKE. Mr. Sullers was reinstated to employment by January of 2019, and the issue that was still being worked out through the grievance process was the back pay. The record shows that TKE was insisting in order to settle the case for the full remedy short of arbitration, that Mr. Sellers dropped his claim with the Illinois Department of Human Rights, which understandably Mr. Sellers was not willing to do, and the union respected that decision and continued to move the grievance through the grievance process all the while until obtaining the full remedy without the need for Mr. Sellers to drop his claim.
Beechner, I apologize to interrupt you. I have a question about the grievance process. And so there was a time delay here. And I'm interested in what's in the record as to the cause of that delay. And if there's anything in the record about the typical timing on processing a grievance.
Yes, Your Honor, it's fair to say that there was a delay here in the process. The union at each stage of the grievance, pursuant to the deadlines, did move the grievance to the next step, and no deadlines were missed, and things processed as they should have. I'll admit there's not a ton of detail in the record that would indicate to the readers of the record, several years on now, identifying exactly what was expended during that time. But I would note that no deadlines were missed. It continued to move through the process. And the next step in the process by which it was settled beforehand was a meeting of the National Arbitration Committee. And in order to conduct that meeting, it requires 3 representatives from both the union, but also 3 representatives from the Employers Bargaining Association, which would include not only TKE, but other, sort of major multinational corporations that are involved in that bargaining association in the elevator industry. And this was also during the beginning of 2020, during the height of COVID. But I will note that there's nothing in the record to suggest that there was any arbitrary, discriminatory, or bad faith reasons for the delay. And the record, supported by Mr. Sellers' own testimony, is that the union, specifically Mr. Gonzalez, the then union business agent, and ultimately the union's business manager, communicated with Mr. Sellers and provided him answers to his questions and concerns every time that he reached out to him. And also, in terms of arguments raised here today by the appellant, I'd like to note that in terms of if the grievance had been styled as a racial discrimination grievance versus a grievance for the layoff itself, the remedies would have been the same. There would have been back pay available for a racially discriminatory layoff and reinstatement. There would have been nothing in the collective bargaining agreement doesn't provide for any further remedies than that in this instance. And so what the union did through Mr. Vallone, the then business manager, when the grievance was first brought to its attention, was to actually recommend to Mr. Sellers to file a claim with the State Human Rights Department to, seek any other remedies that may be available to him, which he in fact did and maintained, and the union respected that he wanted to maintain that claim throughout the processing of his grievance and did not disturb that.
Ms. Bishner, what I hear Mr. Van Pembroek saying in substance, these are my words, not his, but what he's trying to convey, I think, is that when Mr. Sellers had a discussion with Mr. Vallone about the point that you just referenced, the concern about race discrimination and possibly going to the Department of Human Rights, that is adequate notice to Mr. Vallone as union president or as a union representative to include that in a grievance in a world where the union prepares the grievance, not the employee. What's your response to that?
Yeah, so a few things there. That is contradicted by the record. Sellers in his deposition testified that he did not bring any instances of racial discrimination to the union's attention. It was only in his later drafted affidavit after giving sworn testimony in a deposition. And I think that same part of the record was cited here today during the appellate's presentation. In terms of enough notification to include that in the grievance, again, there would have been no difference in the type of grievance that would have been filed, because there would have been no different remedies available to him through the contractual grievance process. And so what Vallone did was provide Mr. Sellers with the best possible information available to him to seek redress for what it was that he was looking for, or for what he may have been entitled to. In addition, in terms of the racial discrimination grievance, had it been styled that way, it actually arguably would have put the burden on the union to carry the burden and prove that case, versus the way that it was styled. It put the burden on the employer to show, had it ultimately gone to arbitration before a third party neutral, that it had just cause to lay off Mr. Sellers. And so in terms of the factual disputes here, the court did not ignore any material facts, nor did the court make credibility determinations. It simply relied upon the record. In addition to the appellant's argument that the grievance form, that there's not sufficient facts for the court to have found that it was Mr. Sellers that filled out the grievance form, there's uncontradicted testimony in the record from Mr. Gonzalez's testimony that Sellers came to the union hall on the day that he sought to file the grievance and filled out the paperwork. And there's no testimony, again, Sellers testified in
the paperwork being the grievance or some other paperwork?
Yes, it's unclear, but that the record at this point says that it was, that Gonzalez testified that Mr. Sellers filled out paperwork regarding the grievance. There was no, unfortunately, follow-up question to identify specifically what that paperwork was. But there's no contradiction from Mr. Sellers other than this later filed affidavit after the parties had given depositions and sworn testimony to indicate that he did not fill out the grievance form. And so there was sufficient evidence in the record to assume that it was Mr. Sellers who filled it out. But in any event, that fact is immaterial because Mr. Sellers has testified that he didn't bring these indications of that he requested to file a racial discrimination grievance until this later filed affidavit, and the remedy would have been the same. So Mr. Sellers cannot prove any actual harm if even we accept everything as true, that he, requested that they file this racial discrimination grievance and that the union failed to do so. But again, there's no record evidence to support that, and it's immaterial given that there would be no actual harm. And there's law within the Seventh Circuit that says the union's under no affirmative duty to investigate and police incidents of racial discrimination, again, with an outside entity here being, this larger multinational corporation who employed Mr. Sellers. I believe the appellant also addressed during his presentation that there was a factual dispute regarding who was carrying the message in terms of that the grievance wouldn't be resolved until unless and until Mr. Sellers dropped his state human rights discrimination claim. There is no factual dispute. Indeed, Mr. Sellers testified during his deposition that the offers that included back pay and reinstatement, but with the requirement that he drop his claim with the Illinois Department of Human Rights, were coming from TKE, and he acknowledged that. And I believe that would conclude my presentation for today, unless the court has any further questions that I'm happy to answer.
I have a question. I hear the union's argument that the remedies would have been the same, but isn't there a value in being heard and having an investigation? It puts the union in a difficult position with respect to other members, but isn't there value in that, even though the end result might be the same in terms of back pay?
Absolutely, Your Honor, and that is why it was the union through Vallone who encouraged Mr. Sellers to file a claim with the Illinois Department of Human Rights. And that's exactly why the union throughout the grievance process respected his right to maintain that claim, despite the employer wanting to resolve the matter by having him draft that, and the union respected his wishes and does think it's very important, and that's exactly why those things occurred.
Okay, Ms. Bitchner, thank you very much. We'll go back to Mr. Van Pembroek.
Thank you, Your Honor. Just briefly, with regard to the claim that there was no information provided by Mr. Sullers of discriminatory conduct related to his layoff, the evidence is very clear that he advised the union that when he was told there was no work for him, he was immediately replaced by a Caucasian mechanic, and that is very clear evidence of discrimination. So this notion that the union was not aware of it is wrong. The affidavit that I cited from Mr. Sullers also recites the fact that he told Mr. Gonzalez about a number of incidences, including some that are very hard to
Yeah,
talk
what do you say to Ms. Bitchner's point about the deposition testimony?
With regard to the affidavit, or with
Regard to
his-
notice of the union that one of the concerns with the layoff was race discrimination.
Right, and what I was meaning to suggest to the court is when the union was advised that they tell an African American that there's no work for him and then hire a Caucasian the next day to fill his job, that is evidence of discrimination, and that was conveyed to the union from the very beginning. Was he laid off with one other person? He was laid off twice, and he was laid off on the second time with another, not a mechanic, but an apprentice.
Caucasian?
No,
Okay.
no. Miss Mitchell, I'm sorry, Mitchell, excuse me, forgive me. She talked about how we can assume that whatever papers Mr. Sullers filled out would have been the grievance, and that is such an anathema to the summary judgment standard, right? We know that there's not a record that will establish that. We know that Mr. Sullers has testified that he has no idea about the grievance process. So to have the trial court assume that somehow Mr. Sullers filled out the grievance and that contradicts his claim about ever wanting the union to pursue discrimination, that doesn't work. That's not proper under summary judgment standard. You should not assume that. And if you're going to make an assumption on this record, the assumption would be that in fact the union filled out the grievance. Thank you, Your Honors.
You're quite welcome. Mr. Van Pembroek, thanks to you. Ms. Bitchner, thanks to you. We'll take this appeal under advisement. We'll now go to our next appeal, which was the first on the published schedule. That is appeal number 24-1427, Hedgepeth versus Britton and others.
May it please the court, good morning. Paul Orphanides on behalf of plaintiff appellant Jeannie Hedgepeth, who is with me in the courtroom this morning, as is my co-counsel Christine Svensson. We are here on the grant of summary judgment on plaintiff's section 1983 claim for a violation of her First Amendment rights. Plaintiff was a tenured teacher with 20 plus years of experience at Palatine High School in Palatine, Illinois. She was terminated for comments she posted on her private Facebook page following the unprecedented looting, rioting, and violence in Chicago and across the country in the aftermath of George Floyd's death in May of 2020. Her comments were neither at work nor about work, but instead addressed important current events. She posted them while vacationing in Florida after the school year has ended. If speech under those conditions can provide the basis for termination, then teachers effectively have no free speech rights left.
She posted this on Facebook, and as I understand, this was on a personal account and in a closed circuit. I'm not very familiar with Facebook. Judges don't use it, but in other words, she had to admit people into this circle. Is that right?
Yes, only people that she designated as her friends could view her private Facebook posts.
So it's fair to say, from your perspective at least, that she took steps to make this private, to limit the circle?
Yes, absolutely.
And apparently her testimony at least is that she did not permit current students to enter that circle. Is
That's
that
right.
correct?
She would not accept friend requests from current students. She would not ask current students to be Facebook friends. I don't believe she would ask former students to be Facebook friends, but she would accept Facebook friend requests from former students.
I see. Thank you.
So it was a fairly small universe of people that would have access just to her Facebook
But
posts.
how many friends did she have? Does the record show?
There was some different testimony. I think there was maybe
Okay, don't-
800 Facebook friends in total, a mix of former students. She does not dispute that some former students were Facebook friends, but with 20 years of experience teaching, some of these people are going to be 38, 40 years old. They're going to be adults at that point. To describe them as part of a community or that communicating with Facebook friends somehow influences the district I think is a stretch.
How large a district is this?
I think there's about 250,000 people served in the districts. I think they have 5 high schools and then 2 specialty high schools.
I see. In the school to which she was assigned, how many students does
I
that
believe approximately 2,800 students and 180 teachers.
have?
So
Senior high school.
senior high school. It's a very, very large high school in the Chicago area.
Counsel, getting back to the Facebook friends and the makeup, I believe I saw in the record that approximately 80% of her Facebook friends were former students. Is that accurate?
I believe there was some testimony to that effect. There was also, it was, there was no clear delineation of the number of people who were Facebook friends, who were former students as opposed to non-former students. But again, with 20 years of experience, you're going to have a lot of people, a lot of adults, people who are all around the country, who end up being your Facebook friends. We raised 3 broad categories of issues that we take with the district court's decision. The first concerned the issue preclusion finding. Under no stretch would I have ever anticipated that the employer's decision on the merits of this case would be credited as a final judgment on the merits equivalent to that of a court of law. Nowhere in our system of justice does a defendant get to be the judge in his or her own case. The judges, the defendants, they were the complainants, they were the prosecutors, they were the witnesses, and if the district court's decision is to be upheld, they were also the judges. That cannot be the law. The only proper way to look at that, the only way that makes any sense is to say they were acting as an employer, not as a court of law. There was a hearing, but the statutory scheme set up by the Illinois legislature is very, very different. This is not some...
At least at the intermediate appellate level, though, the Illinois courts seem to have accepted the board as acting in a judicial capacity with these cases. Isn't that right?
I don't believe so, Your Honor. In fact, I know that the Illinois appellate courts have described the school board as being an inherently interested party.
I know it has done that, and you mentioned that in your brief, but they've also certainly dealt with them as a judicial body.
I have not seen any case, and the defendants did not cite any case in which a court held that a school board was acting in a judicial capacity.
I said
in
dealt
this
with them
circumstance.
as, in other words, didn't decided cases under their, I think it's a certiorari procedure, is that right, in Illinois? Is that what you call it, when a court reviews an administrative agency?
I'm not familiar with the correct term that would govern that type of petition, but I'm not aware of any case in which an Illinois court has said, under the current regime, because the statute changed in 2011. Before 2011, the decision would go, or the process would go from the school district to the Illinois State Board of Education. The Illinois State Board of Education would make a final determination. That was then appealable to the court to the Illinois judicial system. That's sort of the classic administrative review. There was some discussion of the Illinois Human Rights Commission. That's the position that's the process that follows. The Goodwin case that from the Seventh Circuit that the parties have cited involves University of Illinois. In that instance, if a complaint or an issue, an employment issue, is being decided, that goes from the university to the Illinois University Services System, which is a state agency. That can hold a hearing. That hearing, the results of that then are reviewed by a merits board. That merits board can then, that decision can go to the Court of Appeals. But that's very, very different. It never goes back to the employer.
Why didn't your client do the administrative review appeal to the circuit courts? Because she could have if she was concerned about sort of these self-dealing kind of issues. That was not done.
She could have, but at the same time, we'd been litigating for 13 months in federal court. Discovery had closed. We were setting briefing schedules for summary judgment. What's the point of going back?
Well, I'm
starting a
concerned
second
about
lawsuit?
federalism, because then what's the point of the state process if you don't like what happens there, you can just run to federal court, right? Because preclusion, there's efficiency and federalism concerns embedded in that doctrine.
But we didn't run to federal court. We were in federal court when the decision was made. And we've been in federal court. We filed in July
I
of
understand, but there was a
2021.
decision to litigate the First Amendment claim in the state proceeding, correct? That was a strategic decision.
First Amendment claims were raised at the ISBE hearing, and the school board ended up being the judge of those First Amendment claims, and we think that is fundamentally wrong. And even if you were,
I think the point that Judge Maldonado, I think,
You
is
can try.
it's that she made a choice at the outset of this, okay, and the choice that was made before litigation gets going was to seek a hearing, right?
yes,
Okay. She's not compelled by Illinois law to seek an administrative hearing reviewing the recommended termination of the board, correct?
right.
Okay. But when she made that choice, what she did is she set in process administrative wheels started to turn, the ones that you've been talking about. She could have made a different choice, and that was not to ask for a hearing after the board recommended termination, but instead to go to federal court with a Section 1983 lawsuit.
Yes.
Okay, so at least the question to my mind is, could she have, when she did choose to come into federal court with a 1983 action, could she have withdrawn her request for any administrative resolution of her challenge to the board's termination recommendation?
I don't know the answer to that. I'm not familiar enough with that process. She did.
It seems odd that an employee that chooses to set an administrative process in motion cannot then stop those wheels from turning by just saying, I'm delay, change of heart, whatever, preserve the resources on the administrative side. I'm making a choice to pursue a remedy in a judicial forum.
At that point, she had been fired, or she had been suspended without pay for a year. There was no end in sight to the administrative hearing. The administrative hearing
Right, so that
officer-
explains why she went to federal court.
Well, the administrative hearing officer had missed her statutory deadlines for issuing her non-binding findings and
Right, so my
report.
reaction to that is, why not say, to heck with the administrative process, I'm frustrated with it, it's not working, I'm giving up on it, I'm going into federal court. Forget the administrative stuff.
And could she have? I don't know if she could have done something to pull back that. I don't know that it would have mattered.
Does it matter legally? Because what ended up happening where there were two parallel paths.
Mm-hmm.
You had federal court litigation, you had administrative litigation over the same issue.
I don't think it matters, and I don't think it matters for two reasons. First of all, the Illinois legislature and the legislative process does not bind this court or limit its court in its authority about whether to grant preclusive effect to what the school board did here. So
what you're doing with that is you're just saying, you're returning to your point that it's just structurally it's structurally conflicted, it's structurally unfair.
That's correct. That's right. It's structurally unfair to have the defendants, especially in this instance when the defendants had testified in their defense. They participated in discovery. We'd had 13 months of discovery. We'd had defenses. You know, they could have sought a stay if they were concerned about the administrative hearing. They could have sought a stay of the federal court action, or at least raised the issue. They could have filed their affirmative defense saying this is wrong. I mean, it's an affirmative defense. It's not jurisdictional. It was waived. They acquiesced to the federal court litigation. And that is a defense to this race or issue preclusion assertion. So there was no reason why, I mean, they haven't offered a reason why they chose to litigate this case for 13 months in federal court, participate in discovery. You know, but it is where we are, and the fundamental truth of the fact is that we had defendants who had testified and been deposed on on their decision, who had a pecuniary interest in the outcome. They were biased. They were anything but neutral, and yet their decision is being credited as the effect of a judicial determination. If they were the judges in this case, they should have recused themselves. I don't know what would have happened in that circumstance, but I mean, it's fundamentally unfair for the defendants in a case in federal court to say, I've decided the merits of this case, and this court has to be bound by that.
Yeah, and that as a factual matter, you're talking about 3 of the 7 board members, correct? Because the board, this ended up playing out over quite a period of time, right? The board changed.
That's right, but it was a majority of those who voted to adopt the non-binding findings and recommendation of the administrative law of the Illinois State Bar Examiner, hearing examiner.
Okay, you want to save some rebuttal time?
I would. Hopefully we can talk about the First Amendment a bit, but yes, thank you.
Okay, very well. Okay, Ms. Golds, good morning.
Good morning, Your Honors. May it please the court. Haley Golds on behalf of defendants, Board of Education of Township High School District 211, Dr. Lisa Small, Dr. James Britton, Kimberly Cavill, Anna Klimkowitz, Robert Lefebvre Jr., Stephen Rosenblum, and Edward Young. Your Honor, we are asking today for you to affirm the well-reasoned decision from the lower court affirming the defendant's motion for summary judgment for 2 reasons. First, the board's decision was final for the purposes of issue preclusion, and second, because the school district's interest in the efficient management of its schools outweighs the plaintiff appellant's interest in speech in this matter. So, turning first to the issue preclusion question, I do want to address the question of judge, jury, and executioner, and the fact that the interests of judicial efficiency would warrant issue preclusion in this case. The Seventh Circuit has addressed this previously in Rogers v. Desiderio in 1995, as well as in Garcia versus Village of Mount Prospect in 2004. In the Rogers case, the court said, this court deprecates the practice of filing 2 suits over 1 injury. Multiplication imposes needless costs on one's adversary, on the judicial system, and on other litigants who must endure a longer queue. Plaintiffs hope that more suits will improve their chances. They seek the better of the outcomes. To discourage the tactic, judges award plaintiffs not the better outcome, but the first outcome. Whichever suit goes to judgment first is dispositive, and the doctrine of claim preclusion, or in this case, issue preclusion, requires the other to dismiss the litigation. In this case, plaintiff appellant has chosen to file 2 lawsuits, and as Judge Easterbrook pointed out in Davis
Hold on,
versus...
what do you mean by 2? What do you mean by 2 lawsuits? There's a federal court 1983 action, right, which is coming to us, and then there were these administrative proceedings
Sure.
that occurred.
And I suppose
What's
that may...
the second lawsuit?
That may have been imprecise language. The plaintiff appellant in this case has decided to challenge the board's decision to discharge her in two different judicial proceedings. The first being a challenge to the board's decision in front of a neutral hearing officer, and the second being the federal lawsuit. Okay. Your Honors, in this case, in order to determine whether or not issue preclusion applies, the court applies Illinois law that's pursuant to the U.S. Supreme Court's decision in University of Tennessee versus Elliott. In order to determine whether or not a decision is issue preclusive under state law, the decision must have the same parties, it must involve the same issues, and it must have a final decision. In this case, there is no...
Can I give you a hypothetical that would help tease the legal issue out a little bit? Suppose hypothetically, this did not happen factually. I'm making it up. Okay? That the board stated, we accept the recommendation of the hearing officer to terminate the plaintiff. Okay? We're accepting that. But we disagree with the hearing officer's reasons. Okay? And the board's reasons are these. There was actually no disruption that was caused by the Facebook posts. None whatsoever. Okay? But we've had it with the plaintiff's speech because we completely disagree with it.
So your...
Then what?
So the hypothetical is they fired her explicitly because they disagree with her speech, and there was no disruption.
There was no disruption, right? Okay. And we've had it with her speech, and let's add, we don't like her. We're tired of her.
I mean, in a vacuum, outside of any other context.
So the reason I'm asking you the hypothetical is because what I think you need to grapple with is, does that get preclusive effect? So if I change the fact pattern and make it wildly different than the actual facts here, is your position still the same? As a legal matter, it's preclusive.
Yes, because she could have challenged that decision to the Illinois court. She had that ability.
So that's
under
the key.
administrative.
That's the key point in your view, that the reason that this is preclusive is because her outlet is to seek appellate review in a state court of the school board's decision making.
Correct. That is why it's issue preclusive. I believe that there are other reasons that the First Amendment balancing weighs in favor of the school district, but in terms of the actual decision of the school board, if it's correct or incorrect, the fact that she did not seek review makes it final under Illinois law. The Supreme Court in re AW said that a decision is final once the opportunity for appellate review is exhausted. 35 days after the decision of the school board, appellate review.
What do you say to
is
Mr.
exhausted.
Orfanides' point that it's an odd world where the board members, when they make an employment decision, are also 1983 defendants facing money judgments, individual personal money judgments in federal court. That makes them interested parties. It makes them biased. That this is set up in a way that is structurally problematic. What's the response to that?
Certainly. Well, the existence of a problem of structure is a creature of plaintiff appellant's own making. In the first instance, she filed both suits, and she determined that she would file suit against the board members who she was also seeking a particular decision from. I would submit that that would be equal to suing a judge that decided unfavorably for you, and then saying the judge needs to recuse themselves because of their preliminary opinion in your case. But there are other good reasons why.
So is the practical answer to that, she should not have gone down the administrative road. She should have come into federal court under 1983 to begin with. Is that what you're saying?
Well, I'm not saying that she should have gone into federal court, or she should have sought administrative review in circuit court, But either way, she could have brought the claim to an entity outside of the board.
For example?
So had she decided or felt that there was bias, had she felt that the board had erroneously decided that she should be discharged, she could have appealed that decision to the circuit court in Illinois. She could have brought her First Amendment claim and said that the balancing of the hearing officer as adopted by the board was incorrect. She had the opportunity to challenge that decision. She also could have foregone that. I did want to address that the answer to your question with respect to whether she could have withdrawn her administrative challenges. Yes, she could have. She could have withdrawn that and filed her complaint in federal court. The plaintiff in Craig in 2013 did just that. He didn't ask for administrative review of his termination.
Yeah, I'm glad thank you for raising that. Is Craig an Illinois case or something? What's Craig?
Oh, I'm sorry. Craig versus, I want to make sure I get the right. Craig versus Rich Township 227. That's a Seventh Circuit case from 2013. That's a case where a guidance counselor at the school published a book called It's Not Her Fault, which contained a lot of sexual advice.
Withdrew the administrative proceeding?
No, he did not withdraw the administrative proceeding. He just never chose to go forward with it. He only submitted his claim in federal.
Oh yeah, I think that part's clear.
Okay.
Because there's nothing. I think that there's nothing in Illinois law that I see that compels someone in the plaintiff's situation to go all the way through the administrative process. I don't see that anywhere.
No.
They can make a choice to go to federal court by invoking 1983. They can just say to heck with the administrative stuff. I'm not doing it.
Right.
Okay. My question is different. My question is once she has asked for the hearing with the hearing officer and all those wheels are turning, can she say, I'm frustrated with this whole process, it's taking a long time, etc. I would like to withdraw my request for a decision by the hearing officer. Why? Because I'm going to federal court in 1983.
The answer to your question is yes. I don't have the actual statutory language in front of me, but the answer is yes.
And that's in the statute?
I'm not sure explicitly how it's laid out, but the answer is procedurally yes, you can withdraw your challenge of the decision of the board under the school code.
Okay.
So I do want to raise a couple of points with respect to bias that I haven't raised yet. Obviously, I said that plaintiff created the bias by filing the lawsuit. I do want to point out that plaintiff appellant has not alleged that the hearing officer showed any bias or that there was any bias in the administrative proceeding. The school board, when it made its November 2022 order, when it discharged plaintiff, adopted the hearing officer's findings of fact and recommendation in their entirety. So to the extent, maybe if there had been, which we're not conceding, but if the defendants had in some way been biased against plaintiff appellant, there's nothing in their actual adoption of the findings of fact and recommendation that would indicate that that bias impacted their decision. Additionally, the Illinois Supreme Court, again, the body that determines what the law is with regards to issue preclusion, did, in the case of Beggs versus Murfreesboro, which is cited in plaintiff appellant's brief, raise the issue of whether or not board members could be considered neutral arbiters for the purposes of making an employment decision. They said that the board termination process is not partisan, that board members comprising the agency decision maker are assumed to be people of conscience and intellectual discipline capable of judging a particular controversy fairly on the basis of its own circumstances. So it's something that the Illinois Supreme Court has considered in these cases and still found that the board's decision is final, in that case for the purposes of administrative review, but also based on the case law for the purposes of federal 1983 claim.
Ms. Golds, can you go back to the question that Judge Maldonado asked the other side, and that was, am I right in remembering that the plaintiff herself estimated that about 80% of her friends on Facebook were former students?
Yes, that is correct.
Okay. And is there any ambiguity? Those friends would not have included Superintendent Small, correct?
I don't believe so.
Or what's the principal's name? Hanson? I don't
I
remember.
believe it was
Medina.
Medina.
Medina,
Thank you.
yeah, okay. There's no question, though, that the posts made their way outside the circle of friends, correct?
Correct. Within 24 hours, the district was getting complaints from members of the community about the posts.
Okay, and what, by email, by phone?
I believe by phone and by email.
Okay.
On
Was
that,
there any evidence in the record that the teacher's ability in the classroom or her current students' ability in the classroom to learn was in any way impaired by this?
well, evidence of that nature could not be in the record due to the fact that school was not in session. However, I would submit that under the Pickering analysis, you have to consider this in terms of the greater context. So in this instance,
Why?
because the context is important to determine whether or not the speech would so
Well, let's
severely-
talk about that for a minute. School boards are meant to resolve controversies of policy and of employment practices when they arise. That's their job. So the fact that they had to confront this situation is just telling us they had to do their job. They are dispute resolvers in the, as you put it, in the global picture, right?
Correct.
So to tell them they were irritated by having to look at this is kind of it doesn't tell us. All it does is tell them they had a human problem they had to solve. That's what boards do.
If the issue was that the school board members were irritated for having to look at that, that would be one thing. In this circumstance, you have a teacher with 2 prior disciplinary issues involving an inability to deal with students in class, now posting things on Facebook that are offensive in that they dismiss the opinions of a large majority of the student body and the community, and also advocate in some instances violence and call for a civil war and
So now you're telling me that it is content-based.
to the extent that the content was not respectful of the viewpoints of others, yes, there is a certain element of the content being an important
Was it
element of
any,
consideration.
was it any less respectful than what we hear from political candidates in this country?
I think it depends on the political candidate, certainly, but I think if some of the current political candidates were teachers and posting what they post.
Are we supposed to shield our students from the knowledge that our political debate in this country is raucous and that you have to deal with it in those terms?
Under the Pickering factors, there's a higher standard for school teachers because of the government's interest in the efficient operation of its schools than there is, for
See,
instance.
and I'm trying to find out what really was the problem with the operation of the schools, other than the fact that the school board had to deal with this problem.
Sure. And the answer is that the school felt, I mean, among other things, but the most important answer is that the school felt that plaintiff appellant could no longer serve as a teacher, that her students would no longer be able to learn from her, given her history disciplinarily, as well as the fact that she made Facebook posts that advocated for violent reactions and did not respect the opinions of others. She did that despite having had training on social media usage in 2019 and 2020, despite having discipline for reacting to political complaints in a volatile way in 2016. And she did that in a way that even her own expert witness, Dr. Swain, said rejected and criticized the opinions of individuals who are liberals. I would also like to point out that the disruption is not, as opposed to other Seventh Circuit precedent, the disruption in this case is significantly more palpable. It's so disruptive and has such an impact that the plaintiff appellant herself, when the article was published in the Daily Mail, an international publication, asked the Daily Mail to take it down because it was harmful to her reputation. So to the extent that she felt that articles being published that were harmful to her reputation should be taken down, I think the implication on the school district for keeping someone like that on staff when they're receiving hundreds of complaints, when students are saying they can no longer be in her class, and finding that
I'm sorry, and when students say what?
when students are saying that they can no longer effectively learn from her.
Who said that and where?
You know, Your Honor, I don't have all of the comments in front of me, but I know that
Somebody said that
They're in
and
the
where
record.
though? I mean, did students actually testified against her someplace?
yeah, students did submit emails. Students, I believe that there was a student submission to the school board in July of 2020, and I'm not sure about the June 2020 board meeting, but I know that there was a submission from students in the July of
Were there students
2020.
the other way?
I'm sorry?
Did some students testify on her behalf?
I am not certain of that off the top of my head. I know that some individuals did. I don't know if those individuals were students.
I'm sure that some did. It was you'd expect that kind of controversy in the general polity.
Well, given that her posts weren't advocating for one position, but instead suggesting that the other position was wrong and that people who held that position had been hoodwinked and were ignorant.
Suppose you were a math teacher, and as students said that they could not learn from her. Would that be grounds to? One or two students said that. Would that be grounds to fire her? I mean, so I understand it. This teacher has quite a lot of positives in her educational record.
She does have positives in her educational record, but she also has negatives in her educational record in that she was suspended in 2016 for an outburst in which she used the F word twice, in which she said that, you know, students weren't going to be frigging deported now that Trump was president. In 2019, she got upset with a student who was challenging her and told him to do the fucking homework, and also responded
Those were
sarcastically to him.
in-class situations, right?
Correct. But it indicates that
And
there's a
here
reason.
we have a situation where she actually took steps to create a personal audience that did not
Yes.
include students.
She did create a personal audience, but as pointed out, within 24 hours, her posts were everywhere. As I believe it's the Fourth Circuit and Liverman Peters said, social media platform amplifies the distribution of the speaker's message. It increases the potential, in some cases exponentially, for departmental disruption, and thereby favors the employer's interest in efficiency in Pickering balancing. So the fact that it was posted on Facebook, even if it was just to her quote-unquote 800 friends, 80% of whom were former students, and who, despite being trained to the contrary, may or may not have had siblings in the school. She didn't bother to figure out whether or not she needed to unfriend certain individuals because they had siblings currently attending school.
Suppose she had expressed on her Facebook page views on premarital sex.
I think it would necessarily be a contextual question. Was she previously disciplined? Was she denigrating a former student's opinions and saying that that former student had been hoodwinked? Was she saying that people who engage in premarital sex should be sprayed with sewage? I think it's, there
So
are
what you're
specific
telling me
facts
is
here.
teachers can express some views outside as long as they do it quietly, or as long as they express moderate opinions.
No, it has nothing to do with the moderation of the opinion. It has to do with the Pickering balancing. It has to do with the disruption that's caused in the school. It has to do with whether or not, based on the speech, the school has a belief that the individual can still serve in that position. And
I think we have your point, and I noticed that we've
Yes.
gone over time. Thanks a lot.
thank you.
Thanks, Ms. Golds. Let's give you 4 minutes on rebuttal.
That was quite a rhetorical flourish at the end there, so there was a lot to respond to. I think what it really does is highlights all the disputes of fact about how to interpret the posts. You know, there was no one was advocating violence or civil war. That's just a false construct. But that's the nature of the dispute. That's why a jury needs to decide how these posts should properly be interpreted. I don't think she was disparaging anyone's comment or views. She was advocating she was challenging the traditional notion, the traditional notion or the traditional views on race in the United States. And she did so citing scholars, Thomas Sowell. She encouraged an adult to read Thomas Sowell. That is somehow disparaging people's views? I don't think so. She cited accurate statistics. I mean, this is the fundamental dispute: is how do you interpret these posts? And we think that a jury has to decide that issue. It's not something that can be decided by a court on summary judgment.
What's her burden in your view on summary judgment with respect to coming back to the school, to the defendant, the district, not the individuals, the district, on what the evidentiary record shows on disruption?
The disruption, well, that's another interesting question, because opposing counsel said there were hundreds of communications. There weren't hundreds. We disputed. There was a lot of double counting, triple counting, quadruple counting. At some point, emails were forwarded between school board members, and they were counted twice. You know, we gave
That's
the
all
numbers
fair,
in
but
our
what
brief.
I had in mind in the prior colloquy was in paragraph 45 of the summary judgment submission, the plaintiff's response to your statement of undisputed facts.
Mm-hmm.
There, on the disruption point, your client set forth as a factual matter, the principal, Tony Medina, heard from many people, or not your client, I'm sorry, many people, including multiple school staff and then current students who wanted to speak over Zoom and in person to discuss the posts, et cetera, where the concern being raised was how interrupted the teachers and students were by the posts. So what's your client's obligation in summary judgment with respect to that evidence?
Well, first
I mean,
of
I
all,
know you're saying it should go to a jury, but there's no, under Rule 56, there's no obligation to come forward with evidence?
First of all, we objected to some of that testimony, and the district court sustained that objection. It found, with respect to complaints by teachers or concerns raised by teachers, that there was no evidence in the record that supported that assertion. The defendants didn't address that. They haven't responded to that in any way in this appeal.
Sustained it where? In the summary judgment ruling? Because there's no trial or anything.
Well, I always object to evidence in summary judgment because it's a good practice. If you practice in California at all, they do it all the time, and it teaches you. It's a good thing to try.
All right. Well, I don't mean to sidetrack you on that. Go ahead.
I believe it's we cited it in our brief. And the other issue is that I wanted to raise with respect to this alleged disruption. There's a line between what is a heckler's veto and what is proper consideration. Craig, Mel out of the Seventh Circuit, Melzer out of the Second Circuit, make that distinction between members of the public and parents and students. The overwhelming majority of the people that were complaining or contacting, communicating with the district were outsiders. They purported to be members of the community. We don't know that for a fact. Some were part of an organized campaign. Some were put together by a gentleman who was seeking to get elected to the board and did getting elected to the board, so he used this as a vehicle to advance his political ambitions. Our tally, 9 parents, 5 students. That's it. That's really not very impressive when you're going to weigh that against a teacher's First Amendment rights about speech that is not at work, not about work, not even made during the school year. She was on the beach in Florida, and if you actually read her posts, they are nothing like what they're presented here. That's another factual dispute. Of those 9 parents, 4 were supportive.
Okay.
4 were critical. 1 was a comment.
Yeah, this is definitely in your briefs. Okay. We'll call it at that. We'll take the appeal under advisement with thanks to both counsel.
Very good. Thank you.
Our third argument of the morning is in appeal number 24-1765, the United States versus Leonidas Seguria. morning, Ms. Vaughn.
Good morning, Your Honors. May it please the Court. My name is Denise Vaughn, and I represent the appellant, Mr. Ephraim Leonidas Seguria. This appeal concerns two issues. The first issue is whether the ruse exception to the Speedy Trial Act should require collusion between ICE and the U.S. Attorney's Office. And the second issue is whether the illegal reentry law passes constitutional muster under the Fifth Amendment. In light of this court's recent opinion in Viveros-Chavez, I want to respect that there is now binding precedent on the illegal reentry issue. So today I would like to focus my argument on the ruse exception since the Seventh Circuit has not yet adopted it. My client asked the court to do two things. First, follow its sister courts and adopt the ruse exception as described in the First, Fifth, and the 11th Circuits without the collusion element. And second, to reverse the district court's finding that the ruse exception did not apply in this case. The ruse exception has been considered and adopted in every other circuit court. However, circuits are split on whether the ruse exception includes a collusion element. For this reason, the district court committed an error of law in holding that the ruse exception is only met if there's collusion, as in prosecutorial misconduct.
The circuit courts, at least to my eye, that have acknowledged it have kind of done so in a kind of a theoretical way. Have you identified any circuit court that has actually granted relief on the basis of the exception?
Yes, not granted relief, but they're split on whether they need to include a collusion element and what we
Right,
propose.
but have you found a decision where a court says not only does the exception exist, but this particular defendant is entitled to relief because there was a speedy trial violation?
No, Your Honor, not in a circuit court. I want to focus my argument today on why the Seventh Circuit should adopt the primary purpose version of the ruse exception without a collusion element and why that is the most workable test. The text of the Speedy Trial Act does not include anything about intent. It is just about math. It is trying to provide parameters around the Speedy Trial Act, ensuring that once someone is arrested, the government needs to file an information or indictment within 30 days. As this court knows, a civil arrest does not trigger the Speedy Trial Act, but that's where the ruse exception comes in to ensure that the moment that the civil arrest becomes criminal in nature or that the primary purpose of the civil detention is to prosecute, then that's when the 30-day clock should begin. So the ruse exception should not be an inquiry about government malfeasance. It should just be an inquiry about when the decision was made to hold that civil detainee for the primary purpose of being prosecuted. This would be an objective inquiry versus a subjective inquiry. Put more simply, it would be the ruse exception and not the collusion exception. A ruse can be accomplished without collusion or prosecutorial misconduct. So we would have to make this distinction between a ruse and collusion because the district court found that the ruse exception is an unworkable test that has many iterations.
When did it happen here? Because when I look at this particular timeline, right, the detention, the executive branch's detention occurred on June 15th at the beginning, and then the information at the end of the timeline was filed on July 27th. When does day one tick, in your view, in that from the beginning to the ending point?
It is our belief that the primary purpose of the detention became criminal as early as June 15th. We have proposed 3 dates in our briefing, but I would like to focus the court's attention to June 23rd. So on June 23rd, that is when the U.S. Attorney's Office filed the criminal complaint, and we have testimony from the agent who referred this over to the U.S. Attorney's Office on page 102 of the record, and Agent Falls was asked, why did ICE make the decision about referring it over to the U.S. Attorney's Office? So the question was, on June 23rd, it was decided he was no longer in custody to be deported but not prosecuted, and her answer was yes. So that means that on June 23rd, it was functionally impossible for my client to be deported. The U.S. Attorney's Office indisputably made the decision to prosecute him on that day. So we disagree with the district court's application that there was not a decision on that day for him to be prosecuted.
So we would have to conclude then that within the meaning of 3161B, the Department of Homeland Security effected an arrest of the defendant on June 23rd, 2021?
The arrest for the purposes of the Speedy Trial Act was civil, and it would have started on that date. For
Right,
the
who's
rules
the actor, though?
The
Who-
act,
Who affected the arrest on June 23rd? Somebody had to have done it.
yes,
Some member of the government, right?
yes, it would be ICE. Yes. So we are proposing this test as outlined in Restrepo, and the district court found that Restrepo was the apex of the ruse exception discourse. And since Restrepo, 3 circuit courts, the 1st, 5th, and 11th, have adopted that language that was found in Restrepo, which is one, that the primary purpose of the detention becomes or is revealed to be criminal in nature, and 2, that the subsequent criminal charges is premised on the same misconduct as the civil charge. And this is what we are referring to as the primary purpose test. So for the sake of time, I won't go into each circuit's opinion stating on this, but the 11th Circuit in Drummond stated that it will, in order to invoke the ruse exception, it places the burden on the detainee to establish that the primary or exclusive purpose of the civil detention was to hold him for future prosecution. Similarly, in the 5th Circuit, in De La Pena and Juarez, they dismissed the collusion element entirely and stated that we will only apply this exception where the defendant demonstrates that the primary or exclusive purpose of the civil detention was to hold him for future prosecution. The 1st Circuit, in discussing it, it said that it will not trigger the Speedy Trial Act in absence of collusion or evidence that the detention was for the primary purpose of prosecution. So the 1st Circuit believes that the ruse exception can be met with or without collusion. So even if this court decides that the ruse exception should include an element of collusion, we find that this element has been met, and that was I would like to focus the court's attention to June 21st. So on June 21st, after Agent Falls, who was working in ICE, she learned who was going to be the U.S. attorney assigned to the case. So she emailed the U.S. attorney, AUSA Wagamov, and asked her whether she could have that complaint done before Friday. And in her own testimony, as reflected in the record on page A92, Agent Falls testified that she asked the U.S. attorney this because if the complaint was not filed by Friday the 25th, there was a possibility that he would be put on a flight to Mexico on that day and deported. So what ended up happening, AUSA Wagamov ended up filing the complaint before that Friday. So we see here that that was a clear error by the district court in finding that this was not collusion. This was an intentional decision by 2 government actors to come together to evade the requirements of the Speedy Trial Act. So based on these facts, we find that the district court committed clear error in finding that the ruse exception did not apply in this case, regardless if the exception required collusion. In whichever way that the 7th Circuit ends up adopting the ruse exception, it has been met here. We see that the primary purpose became revealed to be criminal in nature as early as June 15th, as I said, and each day passing, the purpose of his detention was very evidently to be prosecuted. When his A file went from the removal department to the prosecution department within ICE, we see that, again, it was not possible for him to be
So
removed.
let me give you a fact pattern that I don't think is all that hypothetical. If an agent within the Department of Homeland Security is in contact with the FBI or the U.S. Attorney's Office about a non-citizen who poses a serious terrorism risk to the nation, and the DHS or ICE agent says, we're gonna remove Mr. X in 14 days unless you all do something criminally. He poses a serious risk, and we need to get him out of here. And the U.S. Attorney's Office says, all right, we're working on it. We can get to a grand jury, or we think we can get a complaint done within 14 days, but you're holding him, not removing him until then would be much appreciated. That's fairly characterized as a ruse.
Your Honor, it would be a contextual question, of course, but specifically what I'm seeing in that scenario is that the government is allowed to coordinate.
Yeah, you
and-
have you have the Attorney General of the United States through U.S. Attorney's offices, and you have the Secretary of the Department of Homeland Security coordinating with each other on how to address a national security risk posed by a non-citizen. And in my time frame, I mean, this seems to have happened at light speed to me. When I look at this time frame, so I'm trying to build out a little bit more time, 10 days, 2 weeks, a month.
Yes, Your Honor. So specifically in this case, we're seeing that even before he was picked up, they were doing calculations about how they were going to handle my client. They were calculating, the arresting officers were calculating, okay, are we going to administer Miranda warnings? And the testimony showed that they do this in cases where they suspect that this person is going to be prosecuted so that those admissions would be able to come in to the case. So in our case, we're seeing that it goes beyond the level of coordination, but we're seeing that my client was picked up by ICE, but in actuality, these arresting officers already knew that they did not plan to remove him, but it was very likely that he was going to be prosecuted. So what we're arguing here is that as soon as that purpose becomes revealed, then that's when the ruse exception or the 30-day clock should begin. And the reason for that is that we want to adopt this ruse exception is because we want to make sure that we're achieving the purpose of the Speedy Trial Act, that we're not unlawfully detaining people who are, in federal custody, albeit civil or criminal. So once it becomes criminal, then they should be afforded the right of the Speedy Trial Act, and that's what the ruse exception is trying to reconcile, the clear text of the Speedy Trial Act.
Okay, you want to save some time for rebuttal?
Yes, Your Honor.
Okay.
Thank you.
Very well. Ms. Vaughn, thanks to you. Mr. Fullerton, good morning.
Good morning. May it please the court. The district court correctly found that the immigration authorities and the U.S. Attorney's Office, or the federal criminal authorities, did not collude in any way or try to scheme to get around the requirements of the Speedy Trial Act, and that would have been required to apply the ruse exception, which has not been adopted by this circuit but had been adopted by other circuits. That factual finding is clearly correct. It's not erroneous. There was no evidence in the record to show that the defendant had been arrested or apprehended at the request of federal criminal authorities. He had been identified by immigration authorities who had gone through the records of people who were held in custody in Illinois state prisons. Mr. Seguria had been deported 6 times previously and had been twice convicted of unlawful reentry after deportation. So he was a candidate for removal, whether or not the federal criminal authorities said anything about him. So he gets apprehended on June 15th. On June 21st, one of the immigration authorities, whose job it is to review detainees for possible prosecution, went through and identified Mr. Seguria as a possible candidate for prosecution. And as Your Honor indicated, with lightning speed, had his fingerprints compared to make sure that indeed he was the man who had been deported previously, and that same day made a criminal referral to the U.S. Attorney's Office between 5 and 6 p.m. Within 2 days, on the 23rd, there was a criminal complaint charging Mr. Seguria with the 1326 violation. At no time was he being held. The evidence showed that at no time was his detention at the request of the criminal authorities or prolonged by the criminal case, or that the conditions of his confinement and detention were materially altered by the fact that these charges had been filed on June 23rd. On June 24th, then, when the immigration authorities received the warrant from the magistrate judge, then there's some delay built into getting him transferred to down here to make his initial appearance on the complaint. And that was entirely reasonable. Mr. Seguria was in custody for the immigration detainer, and he has not shown, the record did not show, there was no testimony that he would have made that flight on Friday, June 25th, in the absence of the criminal complaint, or indeed that he would have made some other flight. It was, as one can imagine, there were a lot of people to juggle, a lot of people in custody, a lot of kind of logistics involved in getting everybody scheduled and on a plane and have all their proper medication and make sure they didn't have a positive COVID test. So there's a lot of shuffling around, a lot of things to do before somebody gets assigned to a flight back to Mexico. And Mr. Seguria didn't show that he was interrupted in some way in taking a flight like that. So there was no evidence to show that the primary or exclusive purpose of his detention by the immigration authorities was for criminal prosecution. The fact that he was a candidate for criminal prosecution was evident from the very beginning, but certainly there was no guarantee that he would be prosecuted criminally. And there was certainly no evidence that the authorities, either on the part of immigration or on the part of the federal criminal prosecuting authorities, were trying to evade the restrictions of the Speedy Trial Act. In fact, the evidence showed quite the contrary. People were concerned about, well, let's get him out of here. Let's get him moving. Let's get this thing going. Let's make sure he's got his medication. The record was really clear that if there were to be a ruse exception adopted by this court, and the court need not do that because this case does not arise to any form of ruse exception, Mr. Seguria would not have been, was not a candidate for expanding the Speedy Trial Act prior to June 28th, the date he made his initial appearance in this building. So
Mr. Fullerton, can I do have a couple questions for you, if you don't mind. In making your presentation and your argument here this morning, you cast it in terms of there not being any evidence that the primary purpose was detention for criminal purpose. Is the government's position that purpose, primary objective, some kind of form, is that the proper inquiry to make under the Speedy Trial Act, or are you making that more in response to Ms. Vaughn's argument?
Yeah, I'm making that in response to my opponent's argument. I don't believe that is the proper test. I believe the proper test is the one articulated by the district court that's in Cepeda Luna, I believe the Ninth Circuit case from the early 90s, which kind of launched this doctrine, which is that there has to be a showing that there was collusion to evade the purpose, the restrictions of the Speedy Trial Act. That's what the district court applied and found there was no evidence of that. But even if it were a primary or exclusive purpose test advocated by my opponent, there's also no evidence of that.
Okay, and then my final question is this. Ms. Vaughn, I think she's done a quite fine job at raising a broader concern on a fact pattern that may lend itself to an inference of conclusion. So let me give you one hypothetically. Forget the detainer at Cook County scenario. And suppose you have an individual affirmatively in ICE custody. And FBI, not FBI intel, FBI law enforcement, in coordination with the U.S. Attorney's Office, are, while in ICE custody, regularly interviewing the individual, thinking that he may cooperate, perhaps. He's agreed to talk every single time Mirandized, and it being told to him that the reason you're being held is because there's a quite serious criminal prosecution or criminal investigation relating to the matters we're talking about. And the Department of Justice has coordinated with DHS, do not remove this man while we pursue the criminal investigation. Hold him. Would you agree? That's a much more concerning fact pattern. I'm not suggesting that happens. I'm making it up.
Yeah. I understand, it's more concerning, but I don't think the Speedy Trial Act speedy trial rights don't attach until somebody gets charged and arrested, or arrested and charged. Because no charges are hanging over that person's head. A detainee in immigration custody is expected, as I understand it under the statute, to be deported within 90 days. So the detainee may have some rights under the immigration law to a review of how
So
long
you would resist the conclusion on a hypothetical fact pattern like that there's really not a de facto arrest by another department within the executive branch.
Correct.
Okay.
So unless the court has any other questions, we'd ask you to affirm the district court's ruling.
Okay, Mr. Fullerton, thanks to you. Ms. Vaughn, you do have some time left. We welcome you to come back.
Your Honor, the government is referring to lightning speed, and that is just simply not the test. The 30 days is the standard. We're not talking about how quickly the government tried to move or what obstacles came in the way. It's the Speedy Trial Act and the Ruse exception is ensuring that as soon as the person is in custody to be prosecuted, that the charges will be coming within 30 days. So there are exceptions under 3161H, but none of those applied in this case about where there would be an acceptable reason for going outside the 30 days. It also was an inaccurate statement by the government to say that there was no evidence concerning this because the A file is the evidence. There is numerous testimony from all the agents that say that the A file determines what happens with the detainee. So when the A file moves from the removal department to the criminal prosecution department, their own witnesses said that it is impossible for that person to be deported. So the purpose then becomes that their detention is now criminal because they cannot be deported. And we also need to address the fact that there is a need to adopt the Ruse exception because the Seventh Circuit would be the only circuit that has not adopted a version of the Ruse exception. This circuit has the opportunity now to instruct a workable version of the test, which we assert would be the primary purpose version of the test, because it would allow us to avoid getting into what the prosecutors or the ICE agents were thinking about, but what actually happened. So the final point that I'll just make is that just because there is a lawful basis to arrest somebody, that does not mean that that is the primary purpose of why they're being arrested. And once the government chose to deprive my client of his individual liberty for the purpose of seeking criminal charges, that is when the Ruse exception is triggered. So we just ask that the court will adopt the Ruse exception and reverse the decision of the district court. Thank you.
Okay, Ms. Vaughn, thank you very much. I see here you accepted this case on appointment from the court, right?
Yes.
Okay, you've done a very fine job. We appreciate you accepting the appointment. Your client should know he was well represented. Thank your firm for taking it on. Mr. Fullerton, as always, thanks to you, Mr. Kerwin. We'll take the appeal under advisement. Thank you.
Thank you.
Our next argument in the morning is in two consolidated appeals, 24-1048 and 24-1082. Erica Mabes versus Shannon Thompson. Mr. Roble, we'll start with you, correct? Okay, good morning. Whenever you're ready.
May it please the court. Both the district court and the Mabes treat legal issues as factual questions. Issues regarding the existence of an emergency, the existence of probable cause, and the sufficiency of the investigation must be addressed as legal questions under the qualified immunity standard. The legal question is whether every reasonable official would understand that a constitutional right is being violated. Qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. In this case, what the district court should have done was looking how each individual DCS official reacted after a 2-month-old infant was found sleeping face down and non-responsive. The parents waited 15 minutes to seek help. An EMT described color returning to the child's body after oxygen was administered. Anoxic brain injury, skull fracture, and abdominal bruising were found at the hospital, and DCS was told by multiple medical experts that the injuries were consistent with abuse. Drugs were found in the house, and the father refused a drug test. Reasonable child welfare workers could rely on those undisputed facts to remove the children from the house, seek court intervention, and substantiate the allegations of abuse and neglect, even accepting all of the factual assertions by the Mabes, which of course we must do. The DCS defendants here should have been entitled to qualified immunity. There are basically 3 deprivations they're alleging here, and I'm happy to address both of those in the limited time, all 3 of them.
Can I ask you about the qualified immunity, though? Here's what I've struggled with. When I look at the district court opinion, we know from our precedent, we know from the Supreme Court, qualified immunity has to be assessed defendant by defendant, claim by claim, correct?
Correct, which was not done here.
Right, and it's very hard to, as a court of review, which we are, it's very hard to review that which was not done that way. And so I observe that to ask you, what are you asking us to do?
Well, I think the important facts here are actually pretty limited, even though we have a very large record, lots of discovery. But this court can look at those 3 claimed deprivations, the removal, the claimed misrepresentations, the preliminary inquiry, and the due process that happened later, and see that what was done here by the DCS workers met the minimal, at least, constitutional requirements. So to answer your question, I think this court does not need to remand. This court can find, without spending that much time in this record, that it's not clear.
To undertake the defendant by defendant, claim by claim analysis in the first instance on appeal?
And we do cite case law in our brief where that has been done in the past, where it hasn't happened yet. And these aren't that complicated of issues, where I think it could easily be done here, where this court can find that, do that analysis.
What's complicated is the multiple defendant part of it. I think there's 7 or 8 different defendants. They didn't play the exact same role.
Correct. And they shouldn't be liable for the actions of the other ones. And we can look at each of the 3 deprivations, and 2 of the defendants, they don't allege really had anything to do with anything. The rest of them, their roles, I think our briefing will make it pretty easy for you to do that, breaking out an analysis, and see that we have all these reasons why there was exigency, why there was probable cause, which would allow the removal. The Chin's representation, that's basically just looking at the preliminary inquiry, basically the probable cause affidavit, and seeing whether or not there are a couple claimed actual factual misrepresentations change the analysis. So I think that's pretty straightforward. And the due process deprivation, at the end of the day, it's basically you can look at whether or not they looked at exculpatory evidence, and they clearly did here. I see my time is up. Thank you very much. We would ask that this court overturn the finding of summary judgment.
Okay, thank you, Mr. Roble. Scoot Wine, good morning.
Good morning, Your Honors. May it please the court. The district court erred when it denied Dr. Thompson's summary judgment on her request for qualified immunity. Picking up on Your Honor's question about what we're asking this court to do, it is to reverse the district court and award Dr. Thompson's summary judgment on her defense of qualified immunity. The issue before you for Dr. Thompson is very straightforward. Neither the Mabes nor the district court have identified any law that would clearly establish that every reasonable pediatrician in Dr. Thompson's shoes would have known that by declining to further credit or consider information the Mabes were providing her in diagnosing their 2-month-old child as a victim of non-accidental trauma, she was personally participating in a constitutional violation. The argument that the Mabes make for the first time on appeal, that they don't have to make this showing as to Dr. Thompson, not only is wrong, it concedes the point. And the clear notice requirement of qualified immunity is the purpose of that requirement is exemplified by the facts of this case. Child abuse pediatricians like Dr. Thompson must act quickly to wade through a variety of information that is presented to them to assess the likelihood that a child is a victim of maltreatment and to figure out a plan to further treat that child. Qualified immunity's clear notice requirement ensures that pediatricians like Dr. Thompson will take steps in those moments to think only of the pediatric patients that they are serving and not of their own potential personal liability if it later turns out that they were mistaken or some other medical expert after the fact would disagree with them. Not only have the Mabes failed to identify any closely analogous case that would have put Dr. Thompson on notice that her conduct was going to be deemed unconstitutional, but construing all of the facts in the Mabes' favor, the Mabes also have not shown that Dr. Thompson in fact violated their constitutional rights. Circling back, what we are asking this court to do is reverse the district court's denial of Dr. Thompson's request for summary judgment on qualified immunity and award her qualified immunity. I will reserve the remainder of my time for rebuttal.
Okay,
Thank you.
very well. Mr. Catlin, good morning.
May it please the court. My name is Brad Catlin, and I represent the Applees, the Mabes family in this case. This is a case about what happens to a family when child abuse investigators ignore this court's clear authority about what they're supposed to do during child abuse investigations. And this court should dismiss this case because there are genuine issues of material fact that affect whether each of the defendants is entitled to qualified immunity. In the time I have today, I'd like to discuss two separate issues. The first one is a child abuse investigator's obligation not to ignore exculpatory evidence when investigating child abuse. And the second one is how Dr. Thompson's role shows that she is liable and not subject to qualified immunity in this case.
Before you do that, can I just
Sure.
pause you, and I'm sorry for interrupting you. Okay, we're here on a denial of summary judgment. Sending a case to trial is ordinarily not appealable, and that's not what the appeal is, correct? The appeal is from the denial of qualified immunity.
Correct, Your Honor.
Okay, and so when you started where you started by saying the case, you didn't say it this way, I'll just shorthand it, that the case is properly going to trial. That's basically what you're saying, because there are genuine issues of fact. Right, okay. All right, that might be if you just go with a Rule 56 summary judgment analysis and apply all the summary judgment standards, okay? But the more that you could focus your comments on the qualified immunity aspect of it, because that's the only basis for appellate jurisdiction, right? In other words, there isn't an appeal of the Rule 56 ruling. There can't be.
You're right, Your Honor. But this court doesn't have appellate jurisdiction if there are questions of material fact that affect.
Travel down that road.
And that's what I intended to do, and I apologize I wasn't clear
Well, I
enough.
probably interrupted you, so maybe it's on me.
So the first thing that I'd like to focus on, which is that obligation this court has already found in DePue and Boyd for child abuse investigators to consider both inculpatory and exculpatory facts and to develop alternate explanations, and particularly not ignore exculpatory evidence. And that obligation, even though we have a lot of different kinds of violations, affects almost every violation in this case. For example, at the time of the initial removal, the evidence that the DCS investigators had, none of it showed that Dr. Mabes herself, who was the mother of the children, posed any danger to the children at all. When asked during their deposition, what evidence did you have that Dr. Mabes ever abused or injured any of her children, the answer was none, other than the fact that she was the mother. And I think that's important in this case, even if you ignore everything else, because in this court's prior decision in Sullivan, you had a situation where a child was obviously a child of a mother and a father, and it was removed from a father because there were concerns that a child had an injury that was the subject caused by abuse. There had been prior allegations of abuse by the father, and they only removed from the father, not the mother. And one thing that this court said was that this court found that to be particularly important because the removal was no greater than was necessary to address the danger. And in this case, at the time of the removal, the DCS workers, when they ordered the removal of the children from their parents, they ordered a much greater removal than was possible. Therefore, Dr. Mabes couldn't have any role in the treatment of her critically ill child as a result of the removal. If we go on to things like when they filed the Chins petition and the things in there, it's still, again, the same basic kind of concept, ignoring the exculpatory evidence, ignoring the evidence that Brian Mabes denied that he ever admitted to using illegal drugs with the children, ignoring the fact that under Indiana law, the fact that there are drugs in the home where the parent uses drugs is not a sufficient basis to find a child is abused or neglected. To ignore the fact that they knew that about the events that happened at Hendricks Regional Hospital.
See, here's the difficulty. I'm going to go right back to where I started. The difficulty is the they before us are either 7 or 8 different people, right? The focus of the briefing, to my eye, is very much on Dr. Thompson. I think, okay, well, let's focus on Dr. Thompson for a minute. But you got all these other people. So I'm being perfectly transparent with you. What's running through my mind are, why not qualified immunity for Lyman? Why not qualified immunity for McFeely, for Crow, etc.? And what you're doing is you're talking about the overarching narrative of the case.
And I apologize, Your Honor. Part of it is I only have 10 minutes, and I was trying
Well,
to be. But
you can respond to our questions,
I can
though.
address that more specifically. So for each individual defendant, other than Thompson, who I'll get to in just a minute, you have Davis and Oakes, who are the initial people who did the investigation. Oakes is the one who said the false things about what Brian said. Well, I think that's a violation right there. Davis is the one who signed and filled out the Chins petition. The information she had in the Chins petition affected the rest of the investigation. We think that she's liable from there. Nobody but those two and their supervisor, Lyman, are responsible for the removal and the Chins petition. It's only those 3 that had involvement there. If you're talking about the CCWAR, the administrative review, Crow has liability for that because she's the one who screwed that up. If you're talking about the reassessment and the investigation afterwards, that's McFeely, that's Crow, and that's Lyman. During none of those, as we conceded in the summary judgment.
Did the district court do any of what you're doing in the courtroom?
The district court did not do that in their opinion. But we did that in our briefing below. We did that in our briefing to you, and we described the different stages at which we think there's liability for each defendant along the way. And we don't think that's an especially difficult job for you. I understand your concern about whether my understanding of your concern is, should we remand back so we can have the district court do that claim by claim, defendant by defendant analysis? I'm not aware of any rule that says they are absolutely required to, and I take no position on whether this court's going to require that and remand so that the court can do that or not. As an advocate, I just want to make sure that the right result is reached. I'm not as concerned about the method that we get there, and the right result is to let this case go to a jury.
You want to say a few words about Dr. Thompson?
Sure. Dr. Thompson, I think an important thing for this court to understand about Dr. Thompson, she's a state employee who is operating according to a state program because she worked for the Indiana School of Medicine, which is a state school. The state program was the PEDS program, which is run under her direction for the Indiana University School of Medicine, pursuant to an agreement with DCS, in which she and her colleagues review 6,000 cases a year to forensically help DCS determine whether children are medically subjected to abuse or neglect. She was clearly acting in that role forensically as an investigator on behalf of DCS. During the course of this case, she didn't offer any treatment. She was just trying to conclude what is the cause of the injury. She wasn't treating conditions. And I think that's an important thing to do, because when you look at the cases that this court has decided, like DePue and Boyd, it doesn't talk about social workers. It doesn't talk about DCS or child welfare investigators. It talks about investigators. And Dr. Thompson was an investigator, investigating where the child abuse took place. anybody who has an open mind to looking at this court's precedent would have seen that anybody investigating child abuse needs to not ignore that other evidence, and she did. And there's a couple of reasons, explanations I can do about that. For example, she talked about the brain injury and that occurred, and how it was something that was caused by accidental head trauma. But she backed away on that later and said, no, it wasn't. In fact, this child was without oxygen for 12 minutes at the hospital. He turned blue and cyanotic. He had had basically no blood flow. He took 44 minutes for him to recover. When the EMTs got to the home, and Dr. Thompson said, well, maybe this happened at the home. When they put blow by oxygen on him, he was at 100% in 2 minutes. I think there's room for a jury to find that there's willful disregard of the facts by Dr. Thompson when she's ignoring what happened at HRH. And the same thing when it happens with the bruise, which they put in there, and she's relying on to say that there was abuse. This bruise wasn't ever seen anywhere at any medical facility by any medical person prior to being at Riley. Dr. Thompson was told about the CPR that was performed there. It doesn't show up in her notes, but Dr. Mabes says she told Dr. Thompson about it, says she told her about what happened, and Dr. Thompson ignored it. Same thing with she told DCS that the brain injury was related to an old skull fracture. But her colleagues at Riley at the time said they didn't see how there was any way that this was related. So the things she told DCS were either recklessly or willfully disregarding the facts that were available to her, jumping to conclusions. And with that, I just ask this court to dismiss this case and send it back to the trial court.
Okay, Mr. Kaplan, thank you very much.
Thank you, Your Honors. I'm going to run through a couple of points. On jurisdiction, the Mabes have made arguments about this court not having jurisdiction, but they've actually identified, especially as to Dr. Thompson, no disputed facts for purposes of qualified immunity. We've bent over backwards in our briefing to accept all of the facts in the Mabes' favor. The court has jurisdiction to hear this appeal. On the question of remand, we cited in our briefing why this court need not remand, and we would strongly encourage the court to not do so and to address, at minimum, Dr. Thompson's qualified immunity argument. The court has explained, that when it's inefficient or unnecessary to remand, it need not do so, and it can decide the merits of the appeal. Here, all the facts before the court are the same as they were before the district court. The court reviews a decision about qualified immunity de novo, and also the policy aims of qualified immunity are that it should be decided as early on in litigation as possible to reprieve officials of having to sustain further litigation if they're entitled to qualified immunity. So we would request this court to actually decide the issues and not remand. On the Mabes' argument that DePue and Boyd set a standard for Dr. Thompson, I want to be really clear that the Mabes abandoned this argument on appeal. They did not make it in their briefing. We raised it in our opening brief, and the Mabes did not respond to it. If you look at DePue and Boyd, those cases do not talk about medical professionals at all. They talk about child caseworkers at the Department of Child Services, or in Illinois, I think it's Department of Child and Family Services, but same thing. Those cases have no bearing on Dr. Thompson. She is a medical professional. She did not have any kind of control over the scope of DCS's investigation. She was there for medical guidance and opinions. We accept that for purposes of this appeal that she was a state actor, a state employee, that's fine, but she's not a caseworker. She is a medical pediatrician who is diagnosing suspected child abuse. She doesn't review inculpatory and exculpatory evidence. She takes no steps to identify who a perpetrator might have been. Those cases simply have no application to Dr. Thompson, and certainly she wouldn't have been on clear notice at the time of these events that those cases extended to her. Qualified immunity has two parts. One is that the constitutional violation had to have been clearly established. The other is that there was a constitutional violation. As to Dr. Thompson, you don't even need to reach the question of whether there was a constitutional violation, because there was no clearly established law identifying for Dr. Thompson or other reasonable child abuse pediatricians that by not considering or crediting certain information that the Mabes were providing her, she was committing a constitutional violation. There's simply no standard out there, and on appeal, the Mabes have not pointed you to one. The other thing I just want to address as to sort of the facts at the time, again, I don't think you even need to reach that for Dr. Thompson, but just to be clear, this is a 2-month-old immobile infant that had an unexplained skull fracture at the time that he arrived at Riley Hospital for Children in Indianapolis, that Dr. Thompson and the DCS professionals first started assessing him. So it is true that there were explanations for certain aspects of his anoxic brain injury, for example, or other things, the bruise, but he had an unexplained skull fracture. That is undisputed. So it is an immobile infant with a skull fracture that the parents do not have a way of explaining, and the evidence is also undisputed that the immobile infant was in the home under the care of the parents. Suspicion was reasonable, whether you say it's, reasonable cause or probable cause. There is just no undisputed facts in the Mabes' favor in the record on this appeal that Dr. Thompson did anything that was reckless, that she had serious doubts about the information that she was communicating, certainly that she did anything willful. So if you were to reach the constitutional violation, there's no evidence of that, but you don't need to. With that, we ask the court to reverse the district court and award Dr. Thompson qualified immunity. Thank you.
Okay. Mr. Gutwein, thanks to you. Mr. Roble, thanks to you. Mr. Catlin, thanks to you and your colleague. We'll take the 2 appeals under advisement. Our 5th argument of the morning is in appeal number 24-1307, Mesco Manufacturing versus Motorist Mutual. Mr. McNamara, good morning.
Good morning, Your Honor. May it please the court, I'd like to have a conversation today about whether the district court's ruling that Motorist Mutual cannot apply exclusions in the insurance policy to an appraisal award, as it's contrary to Indiana's precedent limiting the appraisal process to setting the amount of loss. Motorist Mutual believes that the Indiana precedent was not changed by this court in the Villas of Winding Ridge versus State Farm, such that the district court's order should be overturned. In interpreting interpreting insurance policies in Indiana, these are insurance contracts that are enforced according to the terms, even if it limits coverage. Courts cannot extend coverage and cannot rewrite clear and unambiguous language. And we believe the district court did just that when it limited the reason to deny coverage following an appraisal after an appraisal award under the idea that the issues of late notice or failure to comply with policy requirements are the only bases to deny coverage following an award. Importantly, in Indiana, the case law for more than 50 years is that Indiana has limited the appraisal process to determine the amount of loss. The Atlas Construction versus Indiana Insurance was clear on that. It noted that other possibilities, such as liability, are not determined by the appraisal panel. Appraisal is simply a factual assessment of a claim. It's independent of the legal cause of the damage that's being assessed. The Atlas Court relied heavily on the Mississippi Supreme Court case of Hartford Fire Insurance versus Jones. And Jones explained that unlike arbitration, which is a quasi-judicial process, appraisal is simply a method of ascertaining value or the amount of damages stipulated in advance by the parties.
It can, however, involve the question of causation, can't it?
Under Atlas and its progeny, it says coverage is something that is not determined.
I said causation.
Causation and coverage are not determined with finality by the appraisal panel under Atlas and Wiedemann. While the courts acknowledge that they may determine some aspects of coverage, the idea is the courts and not the appraisal panel are the ones that are supposed to determine whether the loss is covered. That's what's clearly set out by Atlas and Wiedemann.
Oh, your appraiser says you got hail damage. You've got other stuff up there, wear and tear, whatever. I'm looking at the hail damage. This is what the bill is, right? He can do that.
Your Honor, they can determine the amount of loss, but the idea, again, going back to the idea of the Hartford Fire Insurance versus Jones case, which talks about an arbitration where some of that information as to when the hail may have happened and what the condition of the roof was prior to the loss can be put forth to an arbitrator. But under the circumstances, and as we pointed out in our initial brief, the appraisal panel did not have a number of items of information relating to the roofs in question. So by denying Motorist Mutual's ability to apply the exclusions in the policy, such as wear and tear, you've deprived Motorist Mutual of its rights that were set out by the Atlas construction.
You've had this, you or other insurance companies have had problems with this language throughout the United States, haven't you?
Yes, in other states, we acknowledge that courts have allowed coverage determinations by the appraisal panel. However, again, since at least the Atlas case back in 1974, that right has not been granted. And if you look at the appraisal language in the policy, there's no reference to liability. It only talks about determining the amount of loss or the value of the property. Nowhere in there is a reference to liability under the policy.
What do you do with the Villas case?
The Villas case was not a challenge under the right to deny clause. The Villas case was a challenge under the exceptional circumstances, whether there was lack of impartiality by the appraisers, whether there was fraud, whether there was other misfeasance. The Villas case specifically stated that the umpire did not determine coverage. So it was not at issue whatsoever. And that's the position that Motorist maintains here.
Let me ask your opinion on something else then. Given the disarray in the country on this language, the practical ambiguity which Villas causes, whether you can doctrinally distinguish it or not, why don't we certify the issue to Indiana Supreme Court, let them tell us what this language means, at least in the Hoosier State?
I believe that would be an acceptable result to Motorist Mutual, but we don't believe that Villas creates any sort of ambiguity because it did not reach the issue that we're here to discuss today.
I wonder if we, no matter how we decide this and how carefully we parse the language, if you've got Villas in this case sitting there, you haven't, we haven't done much to give certainty to the law of Indiana, have we?
I disagree, Your Honor. I think you would give certainty. Again, Villas was determined under the exceptional circumstances standard. That was the only challenge there. State Farm in that case paid the appraisal award in full. They did not challenge whether there was a coverage decision in that matter. This again, this is Motorist Mutual challenging the decision that there was covered loss to two separate buildings.
Mm-hmm.
So we believe the two decisions can stand on their own.
Can I ask you a question about, you enlisted, or your client enlisted, the help of a fellow named Mr. Barron, correct? Edwin Barron?
Correct.
Who was an engineer.
Correct.
And as I read the briefs, I understood that the charge to Mr. Barron was there's 3 roofs in question, maybe more than that, but at least 3 that this narrowed to. And he was to go out and inspect the roofs and form an opinion about hail damage, correct?
Correct.
Okay. And one of the roofs that there's a lot of argument about is this roof with, this isn't my world, bitumen, modified bitumen. That has to refer to some kind of surface level, surface condition or something.
Correct.
Okay. So when he inspected that, he was of the view that there was either no or very minimal hail damage, correct?
Correct.
Okay. So the difficulty that I have with that is I think that's all for determining what the loss is. That you have to figure out, is there a loss that's caused by hail damage, as opposed to, the reason you put these pictures in the brief, or at least for me, is I thought you were trying to say there's all kinds of things that have happened to this roof other than hail,
Correct.
right?
Yes.
Okay, so you have to figure out, is there damage caused by hail? And if the answer to that is yes, what's the cost to either repair or replace it?
There's also additional questions as to when that damage may have taken place. If say, hail did not fall during the policy period.
I get that. So the right, what are we calling it? The right to deny clause?
Correct.
Okay. That, I understand that if you said, yes, we all agree there was a hailstorm, but it was 2 years before the policy became effective, the right to deny clause would seem to have effect there.
Correct.
Okay. But in a world where we don't have that kind of dispute, and the Mr. Barons of the world are doing what they're doing, it's hard for me to see how, when an appraiser comes up, there's a dispute, we get an umpire involved, and the umpire comes up with an amount, how the umpire is not necessarily concluding two things. One, that there's loss or there's damage caused by hail, and two, it's going to cost this much to repair or replace the roof because of that damage. Because I think, isn't that the whole point of a Mr. Baron?
Mr. Barron was an engineer hired by motorists after it received the appraisal demand and received an estimate that way exceeded the motorist's initial estimate.
Right,
so
because
Mr.
your
Barron
client's
wasn't
position.
Part of the, and
No, I
apologize
know
for-
that, but you enlisted him, I think, because you thought there's no way there was this much damage from the hailstorm,
Correct.
right? And let's get Barron out there and get him up on the roofs looking at him,
And
that's what he did.
And he issued an opinion indicating that there was not covered loss up there.
Right, so why isn't that the kind of stuff that goes in front of the umpire, where you say, Madam Umpire, no, there's no hail damage. This is wear and tear, it's weather, whatever it is, but it's not hail.
I see my time is
No,
up.
you
but
can
Your
answer.
Honor,
Go ahead.
The Indiana, the case law that's developed in Indiana, if Motorist Mutual, which it did here, finds any sort of damage, and the insured says, well, I'm going to demand appraisal, even if motorist says, well, this damage is limited, and in this case, it was to some guttering, downspouts, and the like, but the insured says, well, we think that there's damage to the entirety of all the roofs or whatever it may be, and under those circumstances, motorist has to go to appraisal, even though it's denied a significant portion of the claim, saying that there's no damage. They're under the case law that we've set out in our brief.
No, right, I understand. That's what I would have thought. That's what appraisers do. That's what umpires do.
But in Indiana, it still reserves the right to the insurance company to deny the claim if there is a question of coverage. That is supposed to go to the court, to the jury, to determine whether there is a covered loss under the circumstances. And that's what Atlas and that's what Schifrin, Pebble Point, and the like all
It just
hold.
seems awfully, okay, I got it. I understand.
Thank you.
All right, you're welcome. We'll give you some rebuttal time. Yep. Mr. Byers, good morning.
Good morning, Your Honor. Bill Byers for the appellee, Mesco Manufacturing. I'd just like to make a couple comments real quick to the panel. The Seventh Circuit, from our review, has never issued a decision disturbing the factual findings of an appraisal award. And that's essentially what the insurance company wants in this case. Now, I do this argument between different courts in Indiana probably about 15 times a year. And the way I simplify it for the court, and to address your point about certification, I don't recall a time I've lost this argument. Okay, so this is really a pretty straightforward situation, as I think common sense would dictate. The key is in the dictionary to understanding exactly what's going on. So when you have causation, that is what caused the damage or caused the amount of loss. When you have coverage, you're talking about the risk that the policy insures against. Those are two different issues. right? So for example, if the appraisal panel in this case would have gone out and written up an appraisal award for hail damage, they're determining the cause of that damage as being from hail to the property. Now you can have in some policies, you can have, for example, a roof exclusion. And the roofs aren't covered at all because it's not within part of the risks insured against. You could have a policy, say, for example, that does not cover hail.
Are you arguing, in effect, for a fact law distinction here? In effect, if it's a factual issue, it's in the appraiser's bailiwick. If it's a legal question, i.e., what's covered, what's not under the text of the policy, that's a matter of coverage.
And that's 100% correct, Your Honor. That's the key distinction in this, is the appraisal panel determines the factual situations, and then if there's an issue, right, to dispute among whether or not that you take those facts, match it up to the policy, if that creates an issue of coverage, well then that's something for the court to adjudicate. So for example, let's say that there's a dispute about whether or not the roof exclusion applies, or whether or not there's a cosmetic exclusion in the policy that applies to the claim. A court would look at that, or a matching exclusion. All right, you could have an issue where the policyholder may say, well, there's insurance coverage in my policy for matching, and the insurance company may say it's excluded. But the factual determination, if you look at the Windridge case, for example, decided by this court, the factual determination that the signing doesn't match is not a reasonable match is made by the appraisal panel, because they actually go out there and look at it. So one thing I would also like to point out is the term liability. So when opposing counsel cites the Atlas case to talk about liability is not determined by the appraisal panel, that's an accurate statement, but you have to know what liability means. And liability, because it's talking in the Atlas case, it's discussing liability within the contracts of arbitration. Appraisal is not arbitration, it's different. Liability means basically that the amount owed by the insurance company is decided, okay? And so what you have is you have, say for example, you get an appraisal award back and it's for $500,000, all right? That's not a decision on liability, because the insurance company has to take that. They have to take a look and see what their policy limit is. The policy limit may be only $400,000. Well, then they issue a check for $400,000. There may be a $10,000 deductible. They apply the deductible. That is a decision on liability. So when you take this matter to court, say an appraisal doesn't happen, you take this matter to court, you present the deductible to the jury or the judge. You present the policy limit to the judge. And a verdict, fixing liability, is issued accordingly. Same thing in arbitration. If you submit everything to arbitration, the arbitrators are going to decide what the liability is under the policy.
So it sounds, Mr. Byer, it sounds like you do this a lot.
I do.
Okay. And is it fair to say that someone like Mr. McNamara can go to the umpire with a report from somebody like Engineer Barron and say, there's nowhere near this much hail damage?
And that's routinely
Is that the
done.
kind of stuff that happens?
That's routinely done. And the way it's handled is the umpire, the policyholder's appraiser, and the insurance company's appraiser, they consider it. And they take a look, and sometimes the umpire says, or the other appraisers say, you know what, I think the engineer's right. I'll issue award accordingly. In this case, when you look at the timeline, Mr. Barron's report, whose primary field is accident reconstruction, his report on this hail damage was issued a month before the umpire decision, and from what I recall, Mr. Myers had that available to him, the umpire in this case. But when you take a look at the Atlas case, and this is one of the things that, because they hinge a lot on the Atlas case in no certain terms ever says that the appraisal panel cannot determine causation. That sentence is not within that case whatsoever. The important context of the Atlas case was it was a total loss. So in a total loss from a fire, you're not going to determine causation, okay? So the issue of whether the appraisal panel can determine causation was never precluded by Atlas. Here's the key language from Atlas. And they cite this over and over again, and I've never understand how it helps their position. It says liability is not fixed by means of an appraisal. We've already talked about that. There is only a finding of value, price, or amount of loss or damage. And then it goes on to talk about appraisers are allowed wide discretion and are expected to act upon their own knowledge and investigation. And that's exactly what the appraisal panel did in this case. So when you look at, for example, and I think that Winding Ridge did decide this issue because the policyholder in that case complained that the umpire made a determination on the scope of the loss, and that award was upheld, and no award before this court has ever been disturbed on the factual findings of the award. What this court has issued decisions on is, say, for example, if there are other circumstances where the insurance company does not have to pay that award. So, for example, in Legends Creek, there was an appraisal award, but the suit limitation period had expired before everything got going and got issued, and the policyholder couldn't recover on that award. But the factual findings of the award were never disturbed. So, the other thing I would like to point out, there seems to be, for some reason I've never been able to really understand it, a twisting of the meaning of loss, right? Because the defense says routinely, well, they can only determine the value. And you say, well, the value of what? Well, the hail damage. Well, how much hail damage is there? Well, go out and figure that out, appraisal panel. That's what happens. And so when you look at the meaning of the appraisal language in this case, it says value or amount of loss. Those can be different things. They can also intertwine. And so when you look at how loss is defined in this specific policy, loss means accidental loss or damage. So when you substitute amount of loss for the definition, you read it as amount of accidental loss or damage. That's a fair reading of the appraisal clause using the insurance company's own definition. Granted, it is in a different coverage part, but nothing in that definition section of the coverage part, it is in the property coverage part of the inland marine coverage. Nothing says that that's an unreasonable definition. And so when you look at accident, when you say, okay, appraisal panel, go out and tell me what the accidental loss is or damage, it really makes this question very simple. You just go out and adjust the amount of hail damage that you see out there, and you write up an estimate, and if 2 of the 3 members of the appraisal panel agree to it, that's the appraisal award. I would caution the court, the defense point of view on this would only support a deny, delay, defend policy, which appraisal awards, the sanctity thereof, have been in place for over 100 years, and they're meant so that policyholders can resolve claims without going to court. Their view of things, the appraisal panel would just say, well, how much does it cost to replace the entire roof, without saying the important question as to whether or not the entire roof is damaged by a cause of loss. All right? So, thank you, Judge. I'd ask you to...
Did you have, I mean, I don't want to cut you.
Oh,
Did you have a
I'm
thought?
sorry.
Just finish your thought.
So my point is, if you have an appraisal that determines the amount that it would cost to replace the roof only, without really deciding the claim, well, that'll be on day 1. 3 years later, before a jury, the jury says, well, yes, that roof was all damaged by hail. You can't use that amount anymore because it's 3 years old. It's not fair to the policyholder, right? And so this type of situation would only support a deny, delay, defend policy by the insurance company. The rule of law in Indiana, as discussed by Winding Ridge, is really very clear. The appraisal panel makes the factual findings. The insurance company promptly pays the award like it's supposed to do within 30 days in this case.
Okay, Mr. Myers, thank you very much.
Thank you.
Appreciate it. Mr. McNamara. Yep, we'll give you a minute.
Your Honor, here, Motorist Mutual paid the portion of the appraisal award it agreed was covered damage. And that's typically what happens. And the case law that we've set out notes that a good appraisal award will identify the agreed upon loss and set aside the disputed amount of loss for later determination. We believe the case law is pretty clear from Atlas to Schifrin to Pebble Point that the insurance companies can determine coverage after the fact. Otherwise, you're writing out that last sentence in the appraisal provision. We believe the Seventh Circuit has not confronted this very issue that we have in front of you today. The Seventh Circuit has only been determining the exceptional circumstances challenged by the insureds and not by the insurance company. And we believe the Pebble Point and its progeny are on point, and that the district court's opinion should be overturned. Thank you.
Very well. We appreciate it from both counsel. We'll take the appeal under advisement. That brings us to our last argument of the morning in appeal number 24-1590, Kane versus Colvin. Morning, Mr. Farr.
Morning.
Apologies, may it please the court. I believe that in this case the ALJ committed 3 reversible errors. But before I get to that point, I want to emphasize that the ALJ did recognize that there were significant limitations that Mr. Kane had and limited him to a sedentary residual functional capacity. I think that influences how we should read the rest of the decision, because the judge was clearly not viewing this person as somebody who is basically normal. If you can just do a reduced range of sedentary work, you're not somebody you would expect to see normal results throughout the record, not really limited in any way. So my first issue is that the ALJ did not logically explain his rejection of a physical therapist's opinion. Ms. Turner gave clinical findings supportive of many of her limitations, and most significantly to standing, walking, lifting, and carrying. Her opinion is also consistent with the findings of reduced strength that the ALJ acknowledged in the rest of the record. The ALJ said that the record was otherwise normal, but if that were true, then it wouldn't make sense for him to arrive at the sedentary residual functional capacity. There seems to be a logical gap between his conclusion that this person is seriously limited and yet his belief that serious limitations on a functional capacity evaluation are somehow erroneous because he's really not all that limited. Ms. Turner's sitting limitations are in contrast to the standing, walking, lifting, and carrying based on subjective complaints made by the claimant. But those complaints are consistent with the MRI showing effacement of the thecal sac and neural foramen. And while I'm not a doctor or any sort of medical expert, my understanding is that this is an erosion of the actual spinal cord, where it's pressing in on the spinal cord, which my understanding of the medical literature is this would be consistent with causing back pain when you're sitting down. So it's not as though this complaint, the subjective complaint of sitting issues, emerges out of nowhere. That leads to something that I think is, at least to me, a bit confused currently with the status of the case law, which is whether subjective complaints should be outright rejected by an ALJ or whether they can be considered. And the reason I say this is that the ALJ said that, well, because these sitting limitations and other limitations are subjective in nature, I can discount them.
Can I pause you on that?
Yes.
Can you be more specific? What in our case law is confused or out of whack on this point?
So that's exactly where I was going to lead to, Your Honor. So we have cases like Adair versus Colvin, Price versus Colvin, Mulser versus Colvin, and Thompson versus Berryhill, where they're saying subjective claims are not automatically suspect, and doctors must start with a consideration of the claimant's subjective experience when they're evaluating a patient. Then we have a case like Prill, which says that an ALJ can discount an opinion based on subjective complaints. And just last month, Casson versus O'Malley likewise said that an ALJ can discount based on subjective complaints. So if some cases are saying you can't just automatically reject because it's subjective, but in these other cases the ALJ's reasoning is, well, they're subjective, so I'm rejecting them, I don't know how to connect the gap between these cases. Does that address your question?
Yeah, we'll look at it. I was of a mind that our law was fairly clear on this, in that subjective is just the Social Security jargon for the applicant's own account of
Yes.
his often daily activities and limitations.
Yes.
And as I sit here, I'm not aware of any precedent that tells us to disregard it because it's coming from an applicant. What I am aware of is it is not entitled to dispositive weight. It's not controlling, and it should be considered in light of the totality of what the remainder of the record shows, including the medical evidence on mental or physical impairment.
I agree. But the problem here is that the judge used the fact that it was subjective to discount a medical opinion. So it's not evaluating how strong
Where do
are
you
those
see
subjective
that?
complaints.
Where do you see that in the ALJ's opinion? Or is that more you reading between the lines, or I don't recall anything anywhere near.
I'm sorry, I'm flipping to that right now.
Yeah, that's all right. Maybe you can come back on rebuttal on that if you want.
No, that's okay.
I don't want you to burn your time on it.
I'm on A15, and so it says this opinion, it's about the middle of the paragraph. This opinion does not appear to be supported directly by any positive clinical findings, but rather relies heavily on the claimant's subjective reports.
Yeah, I see it. Okay.
So half of that statement doesn't make sense because there are objective clinical findings, and the judge is acknowledging that elsewhere in the record there's reduced strength, which seems consistent with this report. And then the other half of the statement is specifically suggesting that, well, they're relying upon the subjective complaints. That's wrong somehow. I don't know how else to read that sentence without going into explaining why the physical therapist should not have considered subjective complaints, or even though the physical therapist could consider them, why it was inappropriate in this context. I mean, that sentence presumably has some meaning. So in my perspective, if we're talking about in the context of evaluating this medical opinion, I don't think it's particularly relevant whether or not subjective complaints were a starting point for the physical therapist, because you have to start somewhere with what the individual says. So is there objective evidence connecting to that? Well, we know there's objective evidence showing issues with standing and walking, and that there are postural issues, and that this person is obese. And we know that there's an MRI that shows that this person has a lumbar issue that would resultantly cause issues with sitting for many people. Not all the time. I'm sure there are people who could have effacement of the lumbar spine. Maybe they don't have that same exact complaint because pain is pretty subjective as it is. But I don't think that this is a case where we're just looking at subjective complaint without any sort of underlying objective evidence to tie to it. So using that as a suggestion that, well, the physical therapist considers subjective complaints, this is somehow a weakness, is problematic. But I do want to move on from that issue to the second issue, which is about the state agency psychologist opinions. So the state agency psychologists ultimately found 4 areas of moderate limitations, and their narrative was suggestive of somebody who could do some semi-skilled or detailed tasks. They had some different social limitations. What's especially concerning for me is really that the first consultant found issues with maintaining attention or concentration, and the second consultant actually added to that and said completing a normal workday or work week and performing at a consistent pace would also be impacted. But then we don't really see that reflected in the narrative. And so the judge did not have to adopt that opinion. Perhaps the judge could have said, well, actually, this doesn't make a lot of sense. Maybe I want to send this back, get the consultants to clarify what they want to do. Maybe I'm going to say, well, this logically doesn't add up, so I'm going to reject the opinion. But if the judge is going to say that this opinion is persuasive, then he should either account for those concentration and persistence issues, or he should explain why he's excluding them. But to the extent that he addresses this issue at all, it's just to note that the claimant can complete tasks, which I don't believe Jonathan has ever claimed that he cannot complete a task. So on that issue, it's less about, oh, does the judge have to adopt those opinions? Does the judge have to do anything? He just needs to explain himself, and he didn't right now. The third issue is relating to VE methodology. And I think this might be the most straightforward issue for me, which is just that a vocational expert has to provide enough evidence that the judge can rely on at step 5 to show there are significant numbers of jobs. The ALJ has the burden at that step, and this vocational expert, when asked what your methodology is, it was professional experience. What's your professional experience?
Yeah, is there
I've seen people.
Well, was the issue preserved? I mean, we have quite a bit of case law that says, look, you got to object.
So I would read actually the same case cited by the appellees here, and that's in Lyskane, where it's saying that the ALJ still has the burden at step 5 and cannot accept facially implausible or incoherent testimony. Additionally, even though I didn't specifically say I object to this, I did question it. The vocational expert then said, well, I don't actually place any people in these jobs. There's no connection to, well, how do you get those numbers? And then I did raise this issue on appeal to the Appeals Council, so it wasn't a matter of first impression going into the district court. I specifically noted that the ALJ relied on insufficient testimony to show significant job numbers. So I guess I've exhausted my time, but I think any further questions before?
Not hearing any. Thank you. Okay.
Thank you.
Okay, let's hear from Ms. Johnson.
Sorry.
Good morning, Your Honors, and may it please the Court. I'm Nicole Johnson, representing the Acting Commissioner of the Social Security Administration. So at issue here is the ALJ's analysis of both the medical opinion evidence and the vocational expert testimony. I'm going to take each of these in turn and explain why they were reasonable and well supported by the record. So turning first to the medical opinion evidence, the ALJ reasonably and very thoroughly evaluated the persuasiveness of the medical opinion evidence in this case. And as the Seventh Circuit has repeatedly explained, the regulation's articulation requirement is minimal. And given the ALJ's careful analysis of the opinions in this case, appellant's argument that no reasonable mind could accept the ALJ's conclusions should be rejected. So I'm going to turn first to the physical therapist's opinion, Ms. Mahan-Turner. And this opinion included multiple functional limitations that were not supported by or consistent with the medical record. Now, the ALJ reasonably concluded that it was not persuasive, and he more than minimally articulated his reasons for that. For example, he reasonably rejected Ms. Mahan-Turner's sitting limitations, explaining that they were not supported by her own examination findings, and they were inconsistent with the other medical evidence, including other examinations, which included full range of motion in the back, full arm and leg strength, negative straight leg testing, and normal muscle tone and strength. So the ALJ also found that Ms. Mahan-Turner's opinion regarding shifting positions at will was not consistent with the evidence showing no significant problems with sitting for prolonged periods. Now, the appellant himself conceded in his brief that at least some of Ms. Mahan-Turner's opinion clearly lacked support from her own examination or appeared to be internally inconsistent and contradicted. For example, according to the appellant, there was no evidence to support a limitation on the appellant's ability to move his head. There was no clear support for the limitations related to absences or the need to take frequent or unscheduled breaks. And there was no support for the conclusion that the appellant would be constantly distracted from any simple work tasks. And therefore, the appellant has not shown that no reasonable mind could accept the ALJ's conclusions. But although the ALJ found the overall opinion unpersuasive, he did state the limitations that had more support in the record in the appellant's RFC, and concluded that the appellant was limited to a significantly restricted range of sedentary work. Turning to the prior administrative medical findings from Drs. Larson and Lovko. Here the ALJ also more than satisfied the minimal articulation requirements. Both Drs. Larson and Lovko completed the mental residual functional capacity questions in the first part of the prior administrative medical findings, and then based on those answers, provided narrative opinions about the appellant's functional limitations. Now, the ALJ found these opinions generally persuasive, but did explain where he found some portions of the opinion inconsistent with the record, and therefore he formed an RFC assessment based on the entire record and not just their opinions. Furthermore, the ALJ's analysis and RFC finding adequately accommodated both the doctor's answers to the mental residual functional capacity questions and the limitations in their narrative opinions. The answers indicated that the appellant had a moderate limitation, which the regulations define as a fair ability, in multiple areas related to concentration, persistence, or pace. And these were accommodated by the ALJ's finding that the appellant could maintain concentration, persistence, and pace for 2-hour periods for simple, routine, and repetitive tasks. Now, the appellant in his brief argued that this was no limitation at all because it is the same as the minimum expectation for unskilled work. But being able to maintain only enough concentration sufficient to perform only unskilled or simple, routine, and repetitive tasks, regardless of the length of time the work is performed, is itself a limitation, as there's also semi-skilled and skilled work in the national economy, and there are people who are able to concentrate for longer than 2 hours at a time, or are able to concentrate for 2 hours on more demanding tasks. So the ALJ substantially supported his analysis here as well. And then finally, I'm going to turn to the vocational expert's testimony. Now, Mr. Dunleavy, the expert, testified that there were at least 3 jobs an individual with the appellant's residual functional capacity could perform that existed in significant numbers in the national economy. Now, prior to bringing this case to federal court, the appellant's counsel didn't raise an objection to Mr. Dunleavy's experience, the methodology he used, the jobs he identified, the numbers he identified, or any other part of his testimony. So as an initial matter, this argument was forfeited. But even if not forfeited, Mr. Dunleavy supported his testimony with a reasoned explanation that provided substantial evidence to support the ALJ's findings. Now, Mr. Dunleavy testified that he factored in several sources and he identified those sources. He first explained that he looked to the Bureau of Labor Statistics for his initial numbers. Then he factored in county business patterns. Then he looked at the number of establishments that exist in a certain industry that is likely to be employing people with particular DOT codes. And then he pared that number down further to only full-time positions by using percentages he gets from the Census Bureau. Mr. Dunleavy also testified that he was familiar with the jobs, he had seen them performed, and he had extensive dialogue with other vocational experts on a national level. And this was sufficient for a reasonable mind to conclude that the ALJ's reasoning was supported by the record, particularly given the lack of objection to that testimony at the hearing or in a post-hearing brief. If your honors have any questions. So for these reasons and the reasons stated in the commissioner's brief, the commissioner requests that the court affirm the ALJ's decision. Thank you.
Okay, with thanks to both counsel, we'll take the appeal under advisement. That concludes the day's arguments, and the court will be in recess.
just mention that his ID's in there, just a heads up. Okay, thank you.